All rise. All right, good morning, everybody.
Good morning,
Morning,
Your
Your
Honor.
All right.
Your Honor, for the record, this is civil action 1780-CV033, Patrick Buchanan et al. Versus the City of Greenfield et al.
All right, we have a problem. Juror number 15 in seat number 3 reported to the court officers that her partner had tested positive for COVID-19, and she just tested positive. So, pursuant to our 5th standing order, she's been excused from this jury. That creates a larger problem with the rest of the jurors, okay? And the problem relates to, first, because they have had close contact with juror number 15, they'll be required to wear a mask. I'll be wearing a mask throughout the course of this trial, if anything, to make these jurors feel comfortable. That's presuming they want to stay on this jury, which is the larger problem. They all have been given rapid test kits and have been invited to test now if they wish, okay? I'm going to bring them in shortly. I'm going to entertain any concerns that they may have individually, and we'll see where it goes, okay? So I'll see you all, yes.
There's one other issue that's come up. Ms. Letcher knows the HR director?
Chief of Staff.
Chief of Staff. Used to be the HR director. Chief of Staff for the mayor. Has believed that one of the jurors was an unsuccessful job applicant.
Who is that?
Recently.
I can't, you can have a seat now. Who is that?
Well, she has his name.
No.
She believes it's the
Juror 5, I believe, in the front.
far left front row.
Juror number 33. In seat.
C5, sorry.
Okay.
C5.
Okay.
So if we could have his name, she will recognize it if she gets.
You should have his name.
We don't write them. We don't keep the questionnaires.
Oh, you don't write it down? Okay.
I have the name if you want.
Okay. Mr. Jakinowski will share it with you, and then you can confirm whether or not that is the case. I'll see where it goes, okay? So I'm going to be bringing all these jurors in about 5 or 10 minutes to explain to them what their options are here in terms of the test, okay? And what their obligations are relative to the mask. We'll give you the name of juror number 33, and you can tell me whether or not you need to proceed in that regard. Okay?
And Your Honor, we also, Attorney Keston tested negative this morning again.
The two of you.
The two of us, yes, sir.
Okay. All right, very good. I'll see you, I'll be bringing the jury in just about 5 minutes. So why don't you provide that name right now, and I take it you'll have an immediate response from me.
Yes.
From whomsoever.
As
Okay.
to whether or not it is the
Okay,
person.
I'll see you shortly. Well, ladies and gentlemen, as we say, the plot thickens.
Is now in session? Seated, thank you.
Our 5th order, that is to say the SJC's 5th order regarding access to state courthouses and court facilities, provides relative to prohibited entry, and this applies to everyone, attorneys included, that no person, even if wearing a mask, shall enter a masked state courthouse or court facility, including a building being temporarily used, if the person here, this is the last bullet, the 5th bullet, is not up to date on vaccinations and has been in close contact with someone with COVID-19 within the previous 5 days. So I've just spoken with at the request of our chief court officer, Johnson. I just conferred with the assistant chief of human resources for benefits for the trial court, Jill Sampson, who indicates that up to date on vaccinations means that they have had their booster shot. Okay. And I suppose it might also, there may be an instance where someone has had a second shot, and they've had it recently, and that might be sufficient. But in general, it means that they have had a booster shot because booster shots are now available to all. So first I need to inquire of these two lawyers whether or not you have received your booster shot since you had a close contact.
Well, not since, but I have all four.
When you say
original
not since-
I haven't done any shots since the close contact.
Well, there was just, no, that's not,
No, but
that's
just-
not the question. The question is, have you received a booster shot?
Yes, sir, two booster shots.
Okay, and Attorney Keston.
Yeah, I received my booster shot in
Okay,
November.
so you're all set. Otherwise, we'd have to have you leave. So, the court officers are now making inquiry, and we shall find out where we stand. The jury cannot go below 6 people without an agreement between counsel. If counsel agree, the jury may go to 5, but I don't see how you go below 5, only because we require in a civil trial a 5-6 verdict, which means that if you've got 6 jurors, that 5 of them need to come to an agreement as to each and every question set forth on the jury verdict slip. And if you've got 5 people, that means that every single one of them, since 5 is less than 6, must agree. Okay? And so I don't see how you go below 5, because it has to be 5-6. So let me take a look here, and for your reference, I'm looking at the 5th edition of the Church Hall Bench Book at page 372. Let's see. With 6 to 11 jurors, you can have 1 dissenter. Okay? With fewer than 6, you can have no dissenters. So I suppose the parties might agree to go below 5. I've tried literally hundreds of jury trials. I've never seen anyone agree to do that, but if counsel wishes to do that, you can do that. So right now, the chief court officer is conferring with the jurors, and these are not matters that are done on the record, and that's what we have. Okay. What about this juror number 33?
Juror number 33 in January applied for the position of Director of Communications for the City of Greenfield, and he met with the Chief of Staff, who's here, and the Mayor. He interviewed with them in January. And was not hired. We're trying to remember the exact wording of your question, Your Honor, to the denier about knowledge of witnesses.
Knowledge of what?
Witnesses, when you read the witnesses.
Okay, sure. Hold on.
Just to see if there's a problem with the answers.
Okay. One moment, please. We're now up to October of 2023, if anyone's wondering, for next trial dates.
I think you've made that clear.
Well, no, before it was August, now it's October.
Oh, okay. That's a nice time.
See some foliage in our
Yeah, beautiful.
One moment. Okay, well, they were given a list of witnesses and asked whether or not they knew any of them. No, the questions, there were no questions that went to whether or not any of the prospective jurors has ever applied for a position in the city of Greenfield.
I'm just wondering about the question about knowing the witnesses. What?
There was a question whether or not they knew any of the witnesses whose names I had presented. So,
That's the issue, Your Honor. I mean, it's...
And the witnesses were the, on the defense were Dan McLean, Richard Brooke, Jeffrey Soto, Jason Haskins, Alfred Donovan, Joseph Burge, Laurie Strolin, Blaise Barstow, or Robert Pomeroy.
Who was the plaintiff's witness?
Pardon me?
They listed her under the plaintiff's witness.
We identified
And she being the mayor?
Yes, sir.
Okay. Okay. And he met with her.
He interviewed with her.
Okay.
And it was a high-level job.
Okay.
So I understand the word no is ambiguous, but
The word no?
no, I think you said, did you say, did you know the witnesses? I don't remember the question.
Yep. Okay. Well, I'm happy to make inquiry of him. Let's see where we go on this COVID issue first
sir.
with everyone else. Okay. All right. Very well. We'll report back. Thank you.
Again, we're back on 1780 CV 033, Patrick Buchanan et al. Versus the City of Greenfield.
Thank you.
This is juror number 33-5.
Welcome, juror number 33. You can be so kind as to stand right in front of the microphone. Thanks for all your patience with this morning. We greatly appreciate it. Actually, I wanted to speak to you about a separate issue. It has come to my attention that at least there's been a representation that back in January you applied for a position as Director of Communications with the City of Greenfield, and that you met with the mayor, who was a witness in this particular case, and in particular, Mayor Wiedegartner. Is that correct?
Yes.
Okay. When I asked whether or not you knew any of the witnesses in this case, let's take a quick look here. I don't believe that you had acknowledged that you did, but please correct me if I'm wrong.
I don't believe you asked if we knew any of the witnesses in the case.
Okay. It was one of the questions.
I heard the list of witnesses, but I remember there was not a question posed whether we knew any of them.
Okay, hold on. Actually, you might be correct. Hold on. All right. Do you know any of the parties? Do you know any of the attorneys, any court personnel, any members of the veneer? You're absolutely correct. Okay. But you did know Mayor Wiedegartner, is that correct?
I mean, I only briefly. I don't know her. I met with her for maybe an hour, along with a few other people. But
Okay.
I honestly, truly do not believe that it affects my ability to be impartial in this case, and that's why I answered no.
Okay.
terms of-
In terms of the question whether or not there was any other reason why you could not be fair and impartial?
Yep.
Okay. So as I understand, you applied for a position of Director of Communications and you did not get that job. Is that correct?
That's correct.
Okay. And I'll ask you once again, is there anything about that experience that you believe has affected or would affect your ability to remain fair and impartial?
Absolutely not.
Okay. Why don't I see counsel at sidebar? Okay, I'll note that I asked counsel if they were satisfied with my voir dire, and everyone indicated that they were. No one posed this particular question of this prospective juror. I'll start off with the plaintiffs. What is it, if anything, you wish to say? And if you could please approach so he doesn't hear you.
Your Honor, I have no questions or objection to him continuing this.
Okay, Attorney McDonough.
Nothing on behalf of my clients.
Okay, Attorney Keston.
In the spirit of my
I can't hear you.
in the spirit of my obligation as an attorney, we have to listen to the questions. It's probably due to tell the court what the question you asked.
Yeah, Judge, you asked, we want to see if you know any of these people. If you're familiar with their name, jot it down. We'll talk about it at sidebar.
So, yes.
Yeah.
Okay. So, no, that's correct. I did say, as I generally say, the reason why I'm giving you the names is to see whether or not you know any of these people. But there was no follow-up, which I'll confess was an error on my part. But having said that, okay. Right. So, what's your request?
I just don't know. I'm having trouble.
Well, are you requesting that he be struck or not?
No.
You're not?
No.
Okay, the record reflect that there is no objection to jury number 33 remaining on the jury. Is that correct?
I'm not objecting. I'm just pointing out to the court that question called for yes answer.
That's not. No. Is there?
You should probably ask him.
Ask him what?
Because he said he never had got a question that called for a yes answer.
Well, I understand that, but it's clear that I did say that on something I generally do say. So, jury number 33.
During the counsel can remain. During the course of my comments, I stated, I'm now going to read a list of witnesses to you. I do that so that you can determine whether or not you know any of those witnesses. If you have a writing utensil, feel free to write down any names on the back of your juror card. I did say that, okay? Did you hear me say that?
Yes.
Okay. And at that time, you understood that I was inquiring as to whether or not the prospective jurors had any familiarity or knew any of the prospective witnesses. Is that correct?
Again, I apologize for having this be an issue. I was waiting for the question to be asked, and it was never asked, so I never answered it. And I answered truthfully that I don't believe it's in any way.
I respect that.
I'm very sorry, but like I said, I was waiting for the question to be asked, and it wasn't. And I answered the questions that were asked of me.
And you need not be sorry. There are no aspersions being cast whatsoever. Right, very well.
Right, so, Attorney Keston, are you requesting that juror number 33 be struck?
No.
Okay, thank you. All right, you can return to the jury room. I'm going to be bringing everyone back in, and we're going to resume our trial, okay? You're going to remain on in the jury. It has nothing, sir, please don't take it personally. Thank you. Okay, let's bring him in.
All right, please, recess.
Seems like a nice guy.
Sure.
Real quick question. I noticed it looks
It's close. Someone remembered. It's completely inappropriate. You don't understand. You're the position in open court. I've been saying that. Standing in front of everybody. Yes. They open court. You just fight it.
What is that?
You don't have to stand there. Stand over there. You're accused. That's a good way to handle it. Okay, Judge, you stand there. You understand what you're saying. Newspaper articles, I hear some newspapers that used to prove that this is controversial. It's like, really? Really? You have clues to what you're saying. It doesn't matter.
You're coming, right, John?
I can make them come.
Yes.
Mr. Clerk, can I take the exhibits out of the box?
Oh, yeah, I never got to that. Yes, please, if you don't mind.
But I have to take more.
For some reason, yeah, a little bit, huh?
Done with your
Yeah, I concluded.
Okay, Tim, are you asking him any questions?
Yes.
For about 3 days?
No, for about 15 minutes, maybe shorter.
Thank you for, I actually completely forgot about the box, because I was expecting to give him back to council.
One can hope.
Well, there's still hope on many levels of many things. And the zip drive is there too someplace, right?
Yes, it's under here somewhere.
Yeah, it is. Yeah, just pull that out just so I. All right. We'll adjust those things at some point.
Sure, Andrew. Going all right, please.
All right, welcome back, everybody.
Hampshire County Superior Court is now in session. Please be seated.
All right, we're back on the record. Well, ladies and gentlemen, suffice it to say thank you for all that you have just gone through. Let me just explain a few matters for you so you have perhaps a deeper understanding or fuller understanding as to why we have just done what we did. Why the chief court officer and the other court officers who do a wonderfully expert job have been meeting with you. All that we do in the trial court, as well as in our appellate courts, are governed by different rules and standing orders. And over the past 2.25 years or so, we've had various standing orders that have issued relative to COVID-19. And we have done so in order to assure the public's safety. When I say the public, I'm referring to you, and I'm referring to our witnesses as well as others who appear before the court, including attorneys and court personnel. And the most recent order, which is actually our 5th order, came down just about a month or so ago from our Supreme Judicial Court. And it sets forth requirements for who may come into a courthouse and who may not, as well as mask wearing. And in relevant part, what that 5th order, which governs what we just went through or what you just went through, provides that no person, even a person wearing a mask, may enter a Massachusetts state courthouse, such as this courthouse, if that person has tested positive for COVID-19 within the past 5 days, is awaiting a COVID-19 test result after experiencing symptoms of COVID-19, has been directed or isolated to quarantine, and that quarantine has not yet lapsed, has current symptoms consistent with COVID-19, such as fever, chills, sore throat, or new symptoms of a severe cough, shortness of breath, severe muscle pain, headache, loss of taste or smell, extreme fatigue, nausea, diarrhea, or vomiting, or is not up to date on vaccines, which means being boosted, at least one booster shot that is, and has been in close contact with someone with COVID-19 within the previous 5 days. An important part that standing order also provides for who has to wear a mask. And in general, as you've seen over the past 2+ weeks, you haven't had to wear a mask. That's because we don't require it. Ordinarily, we encourage it, except that masks have to be worn by people either who have tested positive or experiencing symptoms or had close contact with someone with COVID-19 within the past 10 days. Now, obviously, if you have symptoms or tested positive, you're not even allowed into the courthouse. But if you've had close contact with someone with COVID-19 within the past 10 days, you have to wear a mask. So as a result of those provisions, first, as you perhaps already know, one of our jurors is not here because that individual tested positive this morning here in the courthouse for COVID-19. And because you were within 6 feet or so of that individual for a period of 15 minutes or more, which is what we define close contact to be over the past 2 weeks, you are all required to wear a mask while in this courthouse. So I apologize for that, but it is our requirement. The reason why we inquired whether or not you were up to date on your vaccine is that if you had not been boosted, then you would have been excused from service on this jury because, as I just indicated, that if you've had close contact and are not up to date on your vaccines, you can't come into the building. So that's why we asked the questions. We've also given you rapid tests, and we'll give you as many as you wish, actually. You're not required to take a rapid test. That's entirely up to you. We simply provided to you, mindful that you may wish to test yourself either here or at home or wheresoever. It is entirely up to you whether or not to test. So I respect that all this might be a bitter pill to swallow, so to speak. And I greatly appreciate your ongoing presence on this jury. As I've stated to you before, and I'll repeat now, if at any time any of you wishes to speak with me with counsel in the courtroom in the absence of the other jurors relative to any concerns that you might have pertaining to your ongoing service on this jury, then we will hear from you, okay? And so, having said that, the next thing is that obviously our schedule now is we were off yesterday by about, at the end of the day, we were off by about at least an hour or so. So now we're off by about 2.5 hours. And my hope yesterday was that I would have had possibly time to charge you tomorrow afternoon, although I was considering waiting till Monday morning because I don't like necessarily charging a jury and then taking off a couple of days and then have you start deliberation on Monday. But I think it is fair to say that I will not be charging you at least until Monday morning, okay? So that's going to set this trial back. And as I indicated to you earlier, when this case was impaneled, you were told that counsel expected the case to go through the 25th, and that will be obviously well after that particular date. If there are any scheduling issues that you wish to address with me, as I've indicated before, I'll hear from you. So once again, I want to thank you for your patience as well as for your ongoing understanding. We're now going to return to, I believe it was Attorney Ryan's examination of Lieutenant Dodge. Okay, Lieutenant Dodge, you remained under oath.
Which IAs do you want?
Yeah, we can.
The IA for Dodd? The IA for Buchanan. The IA for Buchanan? It's in 46, right? 46. Buchanan is what he's looking for. That's good. That's right.
We can grab you. Yeah.
Sergeant, Lieutenant Dodd, excuse me. Showing you were asked yesterday about IA 12.2-IA
Correct.
regarding Mr. Ting.
That's correct.
And showing you here, this is a conversation you had with Officer Buchanan regarding Mr. Ting.
Yes.
What page is it?
It's the last page.
Last page of page.
Yes. Of 12.21, 12-2-IA. Could you read that aloud?
Officer Buchanan stated, quote, "He's done here." Officer Buchanan stated, quote, "Look at his track record, man. He's done with this department." Officer Buchanan stated he knew when Officer Ting started working for the UMass Police Department. Officer Buchanan stated Officer Ting worked at UMass for approximately 6 to 7 years and then sued the agency and resigned. Officer Buchanan stated Officer Ting then left UMass and started working in Leverett, where he stayed once again for 6 to 7 years before, quote, starting trouble there and leaving. Officer Buchanan pointed out that Officer Ting has now been with the Greenfield Police Department for approximately 6 to 7 years. And like the past two departments he has worked for, he is now going to cause problems and leave. Officer Buchanan indicated he is not surprised by Officer Ting's actions at this point and denied any wrongdoing whatsoever. In fact, Officer Buchanan stated that the two, at one point in time, were very good friends. Officer Buchanan stated he has been taking a proactive role in attempting to resolve the issues between the two, however, has learned that Officer Ting will not even speak with him.
Showing you what is identified as IA 12-17-IA. Do you recognize this?
I do.
Okay, and this was with respect to a bar check?
That's correct.
And who was Brickett Ellis? Who is Brickett Ellis?
Brickett Ellis now owns, I believe, an antiques type store in the town of Deerfield, but he had previously been on the city council.
Okay, and this is dated when, sir?
November 2nd, 2012.
And was there a Facebook posting with respect to this issue?
I don't recall.
If you look at the bottom paragraph on page 1 of the narrative,
Yes.
okay. And what were the officers doing on this occasion?
The overnight patrol officers were asked to conduct bar checks at the close of each night, 1 o'clock, and to ensure that patrons were out of the bars at the required time.
Okay. And who was doing the bar check on this night?
I know Officer Buchanan was one doing a bar check on this night.
Okay, and was Officer Logan involved as well?
Yes,
And the bottom of page 1 identifies a Facebook from Counselor Alice.
that's correct.
Okay, and he had been in the bar that was subject to the bar check.
That's correct.
Okay, and what does those lines read as to his comments?
Sergeant Rice's comments?
No, as to well, Sergeant Rice commenting about the Facebook.
Councilor Alice had posted messages on Facebook which clearly showed his dissatisfaction and made comments indicating he was upset with those who like to abuse their authority and that if elected mayor, he would solve the problem by cutting the budget of the agency involved.
Okay, could you turn to the next page? Paragraph 3, beginning, I explain.
I explained to Councilor Alice that this could not be further from the truth and that I had ordered the overnight watch commanders to conduct these bar checks due to recent problems in town. I also advised Councilor Alice that all bars, not just Red Door, were checked for compliance, all of which were documented in our department's call log. At this point, Councilor Alice conceded that he was upset simply because he had made assumptions relative to Officer Buchanan's intent. Councilor Alice confirmed that there were no inappropriate actions on the part of any officer.
Looking back in front of you, Exhibit 18, if I could take that book back. Okay, thanks. Thank you. And then if I can turn you, Lieutenant, to Exhibit 1, tab 32, in connection with that. Looking at tab 32, that's the scoring formula by the chief for the 2021 promotions?
Yes.
Okay. And within tab 32, there's 10 measures for each candidate.
That's correct.
And it would appear, looking at either Officer Buchanan or Detective Clark, that the highest you can get under any one measure is a 10, correct?
Yes.
Okay. And if we look at that document, the second line or the second box from the bottom is supervisory evaluations of job performance.
That's correct.
Okay. And that would be a 10% component of the total score?
As part of the entire process, yes. I believe, yes.
And
Your Honor, I object to form.
Overruled. Let's move it forward.
And as one of the 4 evaluators, what will be your ranking, if any?
What do you, number-wise?
Percentage.
Oh, then I mean, a quarter of 10%.
Okay. Were you asked to give a numerical ranking of the candidates?
No.
And there's nothing in here where, in those notes, where you were asked to score 1 to 10, most best promotion possibility versus worst.
No.
Thank you, sir. No further questions.
Recross.
Let me take that.
Yeah, yeah.
Yes.
You want the last? Yeah.
I'll put the thing on there. Oh, just change the input. Lieutenant, you were just asked about the 2020 promotional process. Mr. Ryan showed you a ranking. You spoke to the chief and gave Chief Haig, and you talked to Chief Haig and Deputy Williams, didn't you?
I don't know if the deputy was in there. I know the chief and I spoke. I don't remember whether or not he was there or not. I think it was just me and the chief during the
That's how
conversation.
you remember it.
That's how I remember it. It may be
You
inaccurate.
spoke to the chief and you gave input about each one of the candidates, right?
That's correct.
And you had a perfect opportunity to tell the chief that he should promote Patrick Buchanan because he'd be a great sergeant, right?
I don't know that that was part of the conversation.
Instead, what you told the chief is that we've tried it before, it doesn't work, you shouldn't promote it.
I didn't say that.
Well, you've seen the notes, the chief's notes in there, right?
I have.
Okay. Now, again, Mr. Ryan had you read a portion of 1217-IA. I put it up there. Could you find page 2 of that?
What was the tab again?
Rick and Alex, what tab is that?
45. I don't know if he. I think he took it back from him.
Yeah.
It's right here.
Oh, took it back from him?
Yeah. Because
No, you probably took it open.
you take it out. It's,
I'll do it this way. That's the page I want to talk to you about. And Mr. Ryan had you read the first paragraph, the second paragraph, but not the third. The third paragraph, and this was something you wrote? This IA?
Is the third paragraph,
That one. The one-
are you considering Officer Rice relayed this information to me as
The one
well?
that said chief.
That'd be the fourth or fifth
Okay.
in this case, sure.
The paragraph that says chief.
Okay.
Due to several incidents over the past several years involving Counselor Alice and Officer Buchanan. So you were aware that they had had numerous run-ins?
Yes.
And you were aware that Counselor Alice was complaining that Buchanan was targeting him?
I don't recall exactly what the nature of the issues were. It was definitely common knowledge that there were some issues. I don't know specifically what the complaints of Alice were.
You wrote, officers of this department should not have to feel like they have to walk on eggshells while dealing with local politicians. And local politicians should not have to feel like they're being singled out and harassed by our officers.
Correct.
You were aware that the local politicians had been complaining that they were being singled out and harassed by officers, and specifically this one.
This is what was reported to me, and it was what I was looking into, yes.
Now, just so we're clear, you were the president of the Superior Officers Union in January of 2015, right?
Yes.
And you processed agreements on behalf of Patrick Buchanan.
Correct.
And as of that time, as far as you knew, no union in the Greenfield Police Department had ever refused to process a grievance for an officer?
I was aware of a time when we refused to process a grievance. It was Sergeant Dave Rice's grievance, and we did not.
Do you remember me asking you at your deposition?
Yes.
That had ever happened before?
Yes, and I was mistaken at that
And
time.
you told me under oath.
Yep, I was mistaken.
No. Did you not?
I did, and I was mistaken. Yes.
So you agree, though, you told me under, simple question, you told me under oath that there had never been a.
I tell you now that I said it. Yes, it's
Thank you.
yes,
That's
but
a
I was
question.
wrong, as I indicated. Yes,
Now, you're bringing whistleblower time.
that's correct.
And you say, isn't it true that in 2014, when the short list came out, that is a civil service list with only Officer Buchanan and Officer Haskins on it?
That's correct.
Remember that?
Yes,
Known as a short list.
that's correct.
The city does not, the then town, does not have to promote anyone.
That's correct.
The decision is only the mayor's.
Yes,
And you recall, don't you, that you, as the president of the union, one of the unions, had a number of meetings and conversations with the chief and with Deputy Williams about the fact that the mayor was refusing to promote anybody off the short list.
no, I don't recall any such meeting.
Nobody, they never told you. You never talked to them.
Not that I
Neither one
recall.
of them.
Not that I recall.
And did you know in the summer of 2014 that Mayor Martin had indicated he was not promoting anybody off that short list?
I didn't talk with Mayor Martin. I don't know. We had very little contact the entire time he was there.
The question is, did you?
I don't know.
You had no idea.
No.
So, you claim that the thing that you wanted to whistleblow on was your feeling that the not promoting off the short list was due to the race of Patrick Buchanan, right?
That's correct. That's correct.
That's why we're here.
That's correct.
That's why you brought this lawsuit.
That's why I was pursued.
That's
Yes.
why you brought the lawsuit. That's what you say.
Absolutely, that's what I say. I wouldn't be here.
Instead, it is your position that that woman's call should not have triggered an investigation because you've done nothing. Right?
I didn't say that. No, anything should be investigated. I believe I said that to everybody. What shouldn't have happened was
Listen
the
to me.
ridiculous follow-up.
Just a brief moment, Attorney Keston. You are repeatedly cutting off this witness.
Your Honor,
Allow him to finish his statement. Pose a question,
Your
then you
Honor,
answer.
Your Honor, if I may, I'm asking yes or no questions.
You are interfering with this witness's answers repeatedly.
Your Honor, I'm
Pose a
asking
question,
yes-
sir.
I am asking yes.
All right, welcome back, ladies and gentlemen.
We're now back in session, please be seated.
Ladies and gentlemen, has anything come to your attention, indeed since I saw you last night, which has affected your ability to remain fair and impartial, as well as during the various breaks we've taken today? Hearing and seeing no friendly responses, you can take this down, Lieutenant Dodge.
Right here to the sidebar.
Sure. Yes, Attorney Keston.
Your Honor, I state for the record and state to you that I believe you're acting in a partial manner towards the plaintiffs. You are regularly admonishing me. You are objecting to my questions without the other side objecting. You have just told the jury that I'm doing something wrong. When I'm asking the witness yes or no questions, he's allowed to go on. Frankly, it's shocking to me. Yes or no questions, the witness goes on, and the court yells at me. That doesn't cut him off. That's one thing. I feel that a lot of your attitudes have been unfair. You have accused both counsel of stretching out the trial. The ratio is about 2-1 with defender's counsel, greatly exceeding in the estimation. I have not, and yet you say you basically tell the jury they're all lying to you. Number 3, what you did to the juror was terrible.
Which juror?
33. What happened is, we brought it to your attention out of an abundance of caution. The man was put in front of the whole courtroom And it was clear because we're sidelines watching us that we seem to be somehow objecting. So you put us in a spot where we're the ones doing the talking, we're the ones doing the objecting, so he can give something against him. It would never should have been handled that way. That kind of inquiry should never be handled. So I ask you to be fair.
You wish to be heard.
Your Honor, I've lost a number of rulings in this case, so I don't think that there's a partiality.
You wish to be heard.
No, Your Honor.
Okay. I have not been partial toward any party in this case. The rulings have been even-handed. You, Attorney Keston, have persistently, throughout the course of this trial, engaged in interrupting of witnesses in the middle of their testimony. That's exactly what was going on with Lieutenant Dodge just now. Lieutenant Dodge was midstream of his answers when you continuously interrupted him, and that's why I stopped you. As for juror number 33, I inquired whether or not he would be fair and impartial, because you put the issue before the court. And so, and moreover, when I asked you whether or not you wished to strike him, you answered no. Okay. You can pose your next question.
Your Honor, I asked that you instruct the witness to answer yes or no questions, yes or no. Or I can answer yes or no. That's the standard way it's done. To whether the witness
If the question
refuses
is
to answer yes or no.
if the question is a yes or no answer, you can ask him to answer yes or no. But you are not to continuously interrupt witnesses, nor are you to continuously make side comments to these witnesses, which you've done persistently throughout the course of this trial. That is not only unethical, but it's inappropriate, okay?
Yeah, it's unethical to report that.
Okay, you may pose your next question.
Lieutenant Dodge, how many times have you testified in a court of law?
I couldn't be certain. I don't know.
100?
No.
More than 50?
Honestly, I don't know.
Are you aware that when the opposing parties cross-examine you, they typically ask yes or no questions?
Objection, Your Honor.
Sustained.
I guess so.
Please wait till there's a question.
If I ask you yes or no questions, I ask you to answer yes, no, or I can't answer yes or no. Could you do that for me?
Absolutely.
Thank you. Lieutenant Dodge, did you learn from any source in the 2014 that Mayor Martin had indicated he was not going to appoint Upper Short?
No.
Lieutenant Dodge, did you ever learn from any source that the chief and Deputy Williams wanted to go to an assessment center because they were having trouble filling positions?
No.
Lieutenant Dodge, isn't it true that you never told, yes or no, is it true that you never told Chief Hay that you're objecting to his racism?
Is it true that I never told him? Yes.
You never told Deputy Williams?
Correct.
And you never told the Human Rights Commission?
Correct.
You never told the Public Safety Commission?
Correct.
You never told Mayor Martin?
Correct.
Nothing else?
Redirect.
Nothing further, Your Honor.
All right, very well.
Nothing, Your Honor.
Okay, you can step down. Thank you. All right, Attorney Ryan.
Your Honor, the plaintiff has no further witnesses. Plaintiff
Okay, on
rests.
behalf of Mr. Buchanan, the plaintiff rests. Attorney McDonough.
Plaintiff Dodge rests, Your Honor.
Okay, ladies and gentlemen, the plaintiffs have rested. And as I indicated to you preliminarily, that's an important point in the trial, for it marks the close of the presentation of evidence on behalf of the plaintiffs. There are matters that I need to discuss with counsel. I don't know how long it's going to take. And it could take perhaps up to 1 hour. And these are matters that I have to conduct outside of your hearing. Bear with me a brief moment while I see counsel at sidebar.
It needs to be emailed right now.
You don't have it.
We haven't printed, we don't have a printer. It could be printed. We wrote them last night. They're electronic. They're wrong. I suggest a procedure by which you don't act. You make a verbal motion to don't act, you defer until the evidence is finished, because we don't have much more.
Well, I need to see the motion. Where is the motion? I know it's not here.
You can email it to the clerk right now.
That has to happen.
Okay.
If you have a written opposition.
We do, Your Honor.
Okay.
Yours is ready now.
They haven't seen our motion.
Just as to Attorney McDonough, I do not have a written opposition.
I would expect to see a written opposition. That's fine. All right. Aaron? They say they're emailing you the motion. So I don't have it.
Well, they're about to.
Have you sent it yet?
The internet is just connecting to my phone, Judge.
All right, ladies and gentlemen, I'll give you a range from 30 to 60 minutes for these communications. And so, with the ongoing instruction not to discuss the case with anyone, including amongst yourselves, nor to conduct any investigation or research, I'm going to excuse you. I'm going to ask juror number 33 to stay. I do want to speak to you for a brief moment, okay? All right, so the other jurors can leave.
Jury exit.
Attorney Crowley, will you send it to Hampshire for that truck?
Yes.
Thanks.
How many judges is it?
Hold on. Judge, maybe, can we address that after we...
Okay, let's just bring juror number 33 up front, just so where you were standing before, please, sir. All right, thanks again for your patience, sir. You know, earlier I had stated that your being brought forward was no reflection on anything that you did whatsoever. You stated that from the onset of this trial that you believed that you could be fair, that you could be impartial to all parties in this case. You also have acknowledged that you believe that you could remain fair and impartial, okay? I want to make sure, okay, that is the case, simply by virtue of having brought you before this court to pose questions of you, okay? So I'll ask again, and then I'll speak to counsel at sidebar, okay? Is there anything about your having been brought before this court for this discussion that has affected your ability to be fair and impartial toward all parties in this case?
No. I think I'm just embarrassed. And yeah, I'm embarrassed and apologetic.
Okay, well, as I indicated earlier, you need not be embarrassed or apologetic whatsoever. And I wish you to understand that. Mindful that you've stated that you feel embarrassed and apologetic, do you think that you can keep an open mind as you continue to hear this evidence in this case and retire for deliberations?
Yeah, I did.
Okay. I'll see counsel at sidebar. Do you have any further questions that you wish me to pose of juror number 33?
No, Your Honor.
I'm sorry?
No, Your Honor.
Are you satisfied?
Yes, Your Honor.
Attorney McDonough?
Satisfied, Your Honor.
Okay, Attorney Keston, do you have any further questions?
No further questions.
Okay, are you requesting that I strike juror number 33?
Absolutely not.
Okay, very well. Okay, thank you again, sir. You may return to the jury deliberation room, okay?
Am I allowed to tell the other jurors?
No. I'm gonna wait, The instruction not to discuss the case with anyone includes all that we've discussed here. Okay, so respectfully, I'm going to ask you not to do so. I respect that. You might want to explain while you're here, okay? And you can certainly tell them that you're instructed not to discuss it, okay? All right, very well, thank you, sir. Okay. Okay, Harry, do you have that email yet?
Not quite yet.
Okay. All right, and I take it you don't have it either?
That's correct, Your Honor.
Okay. Well, I need to see it before we do anything. And so we're going to simply have to wait its arrival and take it from there. Yes, Attorney Keston, what is it?
Do you want to see all of them or just the one on top? Does Mr. Ryan has not had the opportunity to see our motions yet either.
The plaintiffs have rested, and at this point in the trial, the defendants are to file all of their motions for directed verdict. So I need to see them all. I'm mindful of your suggestion that I reserve, but I at least need to read them before I make that determination. So we will await their arrival, and the reason why I asked how many pages there were, because I'm questioning whether or not we should have copies printed for opposing counsel, but one of them is 33 pages, I guess. How long are the others?
They're not 33 pages. I think in total they might be around 30 pages.
Okay, very well. So I'll ask the clerk's office then to print them off. Once we get them, I'll take a moment to review them, then we'll come back in, and we shall take it from there. Okay, thank you.
All right, welcome back, everybody.
The court is now back in session. May be seated.
All right. I have received and have reviewed, and it took some time to get everything. So I apologize for the delay, but I didn't have all the motions and oppositions right away. But I've reviewed them. I reviewed the opposition that Attorney McDonough had filed. I'm happy to hear from defendants on their motions for directed verdict.
Your Honor, as to Mr. Dodge, I believe we have given you a comprehensive brief on the issue. It reduces itself to this: he never blew a whistle on anyone, to the extent that there is competent evidence, and I don't think there is, as to this conversation with the chief in 2014, in which he alleges that the chief told him that he wanted to find a way to get around civil service. I do not believe there is evidence that Mr. Dodge said anything to the chief, that he was against it. Quite the opposite. That conceptually, if he did, that conceptually could be a protected activity. However, there's no temporal connection. The conversation, he alleges, happened in the summer or fall of 2014. The IA began more than a year later, which breaks there's no temporal connection between the two. So that's the first alleged whistleblowing activity. Plus, we say there is no evidence he blew the whistle or he protested. In fact, he says the opposite. He was quiet. The fact that he talks about what he thought in his mind is not whistleblowing. You have to say it, you have to write it. It also requires a writing. There's no exceptions to the writing. There was no writing. There's never been a writing. As to the second thing, Your Honor, so now we have the filing of the grievance. He alleges the filing of the grievance is an activity protected by the Whistleblower Act. It is not. The exclusive remedy for retaliation for someone doing their job as a union official is the Labor Relations Board, the Labor Relations Act. It's exactly the kind of thing that statute contemplates. That if you are doing your job, such as in filing a grievance, then that's your exclusive remedy. He says it's an emergency. That's particularly silly. The emergency alleged is that he had 48 hours to file a grievance. Well, okay, and he made a writing within those 48 hours, and the writing said nothing about protesting any illegality. A grievance is not the protest of an illegality, does not fit a whistleblower. Most importantly, the central theme of Mr. Dodge's case is that he was retaliated against because he believed that Patrick Buchanan was a victim of racism. And of course, Lieutenant Dodge told no one, orally or in writing, that that's what he was protesting. If Lieutenant Dodge wanted to have a claim that he was retaliated against by that IA because he filed a grievance, he could have done that and filed with the NLRB. If Mr. Dodge wanted to have a claim that he was protesting discrimination in the police department, which he wasn't, but if he did, then he has the exclusive remedies 151B. But of course he never did. He never did blow that whistle. There was no emergency. What's the other exception? Oh, there's life and safety questions. There are limited ways you don't have to have a writing. Mr. Dodge, there is no evidence that Mr. Dodge blew any whistles. In fact, if you look at the facts, there's no evidence of retaliation. They certainly had to do an investigation, and the investigation was done by Chief Williams. It's in evidence. There's nothing in it that's discriminatory. So there is no whistleblower claim, and I also refer you to our papers.
As to your other motion?
We'll rest on our papers on the other motion.
All right. Attorney McDonough.
And if I just may, we're going to rest on our papers, but I do suggest to you that it's also, I'm going to wait for an opposition. It's broken down into different components of Mr. Buchanan's claim, which will have to be addressed at the charge conference as well, because we are proposing verdict questions as to each of those claims, because they're all different.
Attorney McDonough.
Thank you, Your Honor. It appears that the motion really only addresses the protected activity element of the whistleblower claim, and that protected activity is captured in a case that the defendants ignored and didn't cite in their motion, Christo versus Worcester, where the appeals court painstakingly clarifies the three different types of activities that qualify under a whistleblower claim protected activity. That includes, one, Your Honor, a refusal to partake in illegal conduct. Number two, an objection to or threat to disclose the activity that's unlawful. Or number three, that would be participation in it in a process investigating illegal behavior. All three of these. Again, we only need to have evidence of one of these areas, and we have all three. The only one that even requires the writing is, of course, the threat for public disclosure, and specifically no case, certainly no case cited by defendants, and no case ever that's been reported has heightened the writing requirement or added what needs to be in it or added specific content of any kind. It's clear that as the cases in Christo, and as the SJC has said in Edwards versus Commonwealth, merely all that's required is that you just give the employer a chance to reverse the adverse action, and that's what the writings did here. Lieutenant Dodge has testified under oath that he was objecting to two sets of laws. Civil service laws under Mass General Laws 31, sections 1 through 77, and then also the anti-discrimination laws under 151B because of the obvious difference in pattern, of which there's a tremendous amount of evidence here that when there's discretion and it's a white officer, they get progressive discipline or excellent discretion. And when it's Officer Buchanan or the one officer who spoke up for him, they go from zero prior substantiated misconduct to, in Mr. Dodge's case, the maximum suspension here. So again, that last part really knocks out the temporal argument by Attorney Keston because, first of all, Dodge was disciplined in less than 2 months of the arbitration decision for Buchanan, and he had no discipline. And the arbitrator even noted this is excessive. And he said that this is excessive and unjustified to give someone a maximum suspension who had no discipline. So there's a clear link there that upon which the jury can infer the temporal link. And again, back to the writing challenge, even if it was entertained by the court, that's a genuine issue to be assessed by the jury, whether or not my client met the writing requirement and whether his writings meet that standard. And certainly there's ample evidence that he was objecting. There's also been no testimony, no credible testimony as to any other purpose other than to object to participate in hearings for and speak on behalf of Buchanan based on the unlawful activities of the defendant, specifically Chief Haig's words, to find a loophole around the law. That's unlawful. Their own witness, Pomeroy, agreed that would be disgusting. That's what my client was objecting to, and that's why he qualifies under the whistleblower statute.
Attorney Ryan.
Yes, Your Honor. The prima facie case of discrimination is membership, harm, discriminatory animus, and causation. Obviously, we have membership and we have harm by virtue of the many denials of promotion, the many IAs, and the punishments levied. The discriminatory animus and the causation, Your Honor, begins with the 228-14 promotion of Westerling off a short list. 8 months later, Your Honor, there's a short list with Buchanan at the top. They had just done it for a white officer, for a white candidate for sergeant. And in response, the credible testimony before the court is from the chief. He's lazy, doesn't fit the bill. See what you can do to get around civil service. That puts in motion, Your Honor, the assessment center. It puts in motion, Your Honor, the discipline where they turn a thank you into a 3-day suspension, into a demotion, into a removal as a field training officer. When you look at the treatment of Officer Buchanan and the treatment of that discipline as to the treatment of the comparators, Clark, Officer Rode, who remained on the payroll for months, the non-action with respect to the chief's own matter, the 2018 discipline, Your Honor, where both Westerling and Buchanan are identified in the Donovan report. They get a handful of written statements from the officers, from the white officers against Buchanan. There's no similar evidence. There's no similar written statements with respect to Westerling. The Donovan report is done. It's complete. All the interviews, it's written, it's complete before they even open the Westerling. So again, Your Honor, significant ongoing differential in treatment where Westerling, the problem self-corrected because we've just made an example out of Buchanan. And so there's nothing done with respect to Westerling. He is left untouched, and Buchanan faces subsequent demotion and return to patrol. Further, Your Honor, when you go forward, Clark then becomes the next provisional sergeant. They removed Buchanan effective February 1. They put Clark in effective January 2020. The 2020 promotions, Your Honor, they score Buchanan at a 54. Clark is 26 points ahead, despite the significant issues with Detective Clark. Buchanan is the 5th candidate overall, despite the very low score he gets. When they make that last promotion, which they didn't know was going to happen, they had Buchanan as the next man up, Your Honor. They made a deliberate decision, and it wasn't that, it was the chief, because the mayor testified she didn't see that ranking until she was here the other day. But he made a deliberate decision to withhold the evidence from the mayor, and instead of taking Buchanan as that 4th and final pick, he selected a lower scoring white officer, and all of that, Your Honor, I submit is grist for discrimination claim.
All right, I'll take the motions under advisement. Okay, we'll bring in the jury will step off once they arrive. We'll turn to the defendant's case.
Thank you, Your Honor.
All rise, please. Go stand recess.
All my hopes are dashed. Oh my God. I was openly texting their arguments to show my lack of respect. Rather than yeah. The evidence is
Are we gonna say anything?
huh?
We're saying something.
Yeah. I think so. My dad re-upped the hotel.
You're on your way, right? Yes.
We should prepare for the NCLE and whatever.
Oh, yeah.
How come I have to do it? Why don't you do it?
Do what?
The NCLE.
Because he wants to enjoy the process of it.
I've done it before.
You have?
Yeah.
Oh.
They made me be a judge once. I was a paralegal and I didn't know anything. So there was like an objection. I was like, what do I do? I don't know.
You just say.
Yeah, but what happens when we finish? Which we will. Of course. Which means full. When is this consultation with us before?
Jury entering. Board, all rise, please.
It's like
Hampshire County Superior Court is now back in session. Please be seated.
Welcome back, ladies and gentlemen, and thank you for your patience. Has anything come to your attention since I last saw you in court which has affected your ability to remain fair, to remain impartial? Seeing and hearing no affirmative responses, you may call your first witness.
Can I put it sidewalk, please?
Yes.
My first witness will be then Deputy Chief, now Chief Williams. You had inquired yesterday and asked me to tell you what he was going to rebut. Right. And I told you he was going to rebut the conversation they had when he was put on leave in 2015. I also asked permission to ask him to rebut Lieutenant Dodge's claim that he did not know about the short list of the mayor in 2014. The mayor is the one that was telling me that he was going to hire off the short list. And I intend to ask him, with your permission, to rebut that claim.
Wish to be heard. Yes, Your Honor. The mayor has testified, and the chief has. I'm not even sure the chief has testified on that point. I don't recall that he did.
Yeah, that would be the mayor. We object because the mayor could have testified to that, and we did cover that already.
It's appropriate rebuttal testimony. You inquire. Thank you.
The defendants call Chief Michael Williams.
Mark.
Mark.
Good afternoon, Chief. Thanks for all your patience. Please step up and we'll swear you in.
Thank you. Do you solemnly swear the evidence which you shall give to the court and jury in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth? So help you God, or do you so affirm?
I do.
Thank you, sir. Watch your step as you get to the stand.
Sir, please make yourself comfortable speaking directly into the microphone. Thank you very much.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
Would you state your name for the record?
My name is Mark Williams.
And you are currently employed as?
I am the chief of the East Long Meadow Police Department. Thank you.
Could you tell His Honor and the jury your educational background, starting with high school and moving up, if there was an up?
Yes, I graduated high school from Turners Falls High School in 1991. Got a bachelor's degree in criminal justice from Westfield State College back then, now university, I guess, in 1995. And then subsequent becoming a police officer, I attended a special state police academy for my time as a campus police officer, and then later municipal full-time police academy, as well as a part-time municipal police academy there as well.
Would you tell His Honor and the jurors your employment history with regard to law enforcement?
Yes, I started in law enforcement in 1994 in the campus of Mount Hoyle College with their campus police department. In 1999, I was hired by the then town of Greenfield as a patrol officer. And in 2010, I was promoted to sergeant. And then in 2014, I was promoted to deputy chief in Greenfield. And then I left there in January of 2021 and accepted the chief of police position in the town of East Long Meadow.
How large is the East Long Meadow Police Department?
We are 27 full-time sworn personnel.
And you've been the chief for about a year?
A little over a year, yes, sir.
So you were, how many years did you serve in Greenfield as a sworn police officer?
Would have made it about 21 years, I believe.
Did you work with Chief Haig in his first incarnation in Greenfield?
Yes, I did.
Before he went back to Orange?
Yes, I did.
And did you work with Officer Buchanan?
Yes, I did.
Career in Greenfield?
Yes, I did.
Did you work with now Lieutenant Dodge?
Yes, I did.
Sir, in 2014, you became the deputy chief?
Yes.
And what kind of process did to make sure Greenfield was a civil service department?
Yes, it was at that time.
And you went through what process to gain your position as deputy chief?
I went through an assessment center.
Was it run by BashQuest?
Yes, it was.
Now, in your role in the summer of 2014, did you have discussions with Chief Haig about hiring lieutenants and sergeants?
Yes.
Did you have discussions with then Sergeant Dodge regarding promotions in the Greenfield Police Department?
Yes.
Did you talk to Sergeant Dodge about, well, let's talk about lieutenant. There was a promotion opening for lieutenant.
Yes.
And we've been using this courtroom the term short list. Is that a term you're familiar with?
Yes.
How do you understand a short list with regards to civil service?
I understand that to mean there is less than 3 eligible candidates willing to accept appointment to a position.
And you're aware that the mayor at the time was Mayor Martin?
Yes.
Who had the power to appoint employees in the police department or promote?
Mayor Martin.
Do you become aware that Mayor Martin had promoted Sergeant Westerling off a short list?
Yes.
Was that a topic of discussion with Lieutenant Dodge?
Yes.
What did Lieutenant Dodge have to say about the promotion of Westerling?
The short list I remember discussing with him was involved Sergeant Westerling being on a short list for the lieutenant's position.
And Lieutenant Dodge was against it, right?
He was against promoting Sergeant Westerling to lieutenant off of that short list, yes.
Did he say why?
He didn't believe that Sergeant Westerling was an ideal leader and wasn't fitted for that position.
Did Lieutenant Dodge explain to you who he thought the good leader would be to be promoted?
Off of that list, there was no, off of the eligible names, there was no opinion as to.
Did Lieutenant Dodge express his desire to get that job?
Yes.
And did he advocate for a what do you call it, a assessment center for the lieutenant's position?
Yes, I believe so.
Now, there was also, in the summer of 2014, there was a short list for sergeant.
Yes.
Remember, it was Buchanan and Haskins?
That rings a bell, yes.
Were there discussions among you and your deputy chief and the chief about how to hire, how to get the mayor to hire somebody in the summer of 14?
Yes.
Was then Sergeant Dodge privy to those conversations?
Yes.
Did you talk to Sergeant Dodge about the mayor's reluctance to hire anyone off that short list?
Yes.
And were you concerned that you needed sergeants and the mayor would not appoint anyone off the short list?
Yes.
Did Sergeant Dodge in any way, shape, or form advocate for Patrick Buchanan to get that job during those discussions?
No, he did not.
Did Sergeant Dodge participate with you and the chief in getting an assessment center for the sergeant's position so you could hire somebody?
Objection, Your Honor. Scope.
Sustained.
As far as you could tell, was Sergeant Dodge aware from you and or the chief that it was the mayor that wasn't going to hire, didn't want to hire off the short list?
Objection, Your Honor. Speculation and scope.
Sustained. Speculative.
You had discussions at which Sergeant Dodge was present regarding the topic of the mayor's reluctance.
Objection, Your Honor. Asked and answered.
Overruled.
Yes.
Thank you. Now, in late 2015, did you become aware of an issue regarding Sergeant Dodge allegedly disclosing the name of an informant to a felon?
Yes.
Objection, Your Honor.
Sustained. Answer is struck. Outside the scope.
As a result of what you learned, did you and the chief make a determination as to whether or not you should put Sergeant Dodge on administrative leave?
Yes.
And you know what that letter is? The leave letter. It's letter to
Which letter?
Dodge.
Oh, the leave letter. That's right. Sorry about that.
Do you recall arranging or participating in a meeting between you and the chief and then Sergeant Dodge with regard to putting him on leave?
Yes.
Remember the day of the week of that meeting?
It was a Saturday morning.
In order to get ready to testify today, have you reviewed any documents?
Yes.
What did you review?
I reviewed a copy of the internal investigation report that I wrote.
And the meeting was on a Saturday. Where was the meeting?
In the chief's office.
Tell us what happened.
We somehow contacted Sergeant Dodge to come in and meet. He did come in a short time later and met with the chief and I in the office. Would you like me to?
Well, so before Sergeant Dodge came in, did somebody else come in to see you?
Objection, Your Honor.
Overruled.
Yes.
Who was it?
One of our dispatchers, Sarah Guidaboni.
And what did she say?
Objection, Your Honor.
Sustained.
Not being offered for the truth.
Sidebar.
What do you anticipate his testimony will be?
That you received a text, you testified to it, from Lieutenant Dodge asking if she had made a complaint against him. Okay?
This is a surprise and not within one of the limited areas he said he was going, and it does not rebut anything that was testified to by my client, which was essentially what counsel just proffered.
Your reply.
So it's not a surprise.
Your reply.
That's true. No. His client did testify about it.
Your reply to the objection, please.
My part of the objection is that his client thinks he was given any information at this meeting.
The objection's overruled.
Thank you.
You may respond.
What did Ms. Guidaboni say?
She said, I just received a text from Sergeant Dodge asking if I was making a complaint against him because the chief was calling him in. Something similar to that effect.
Ladies and gentlemen, that testimony is not being offered for the truth of the substance of that message, but simply that is what was stated. Let's proceed.
Did Sergeant Dodge make inquiries about that possibility during this meeting? Possibility that this was about Ms. Guidaboni?
I don't remember that coming up specifically, no.
Okay, when you put someone on administrative leave, you could just do it by letter, right?
Correct.
But you guys decided to meet with Sergeant Dodge.
Correct.
Talk to him face to face.
Yes.
Please tell us on the jury what information you gave him about what was going on.
We gave him a written notice of the allegations of the rules and regulations that were potentially violated and subject to investigation. We didn't get into exact details of exact allegations, but rather stated generally this is what is being alleged has happened, and we felt it was important to be investigated, and that it couldn't be really fairly investigated for him or for the department if he was still at work while it was being investigated. And then the chief also advised him that due to the nature of the allegations, he felt that it warranted a review from the district attorney's office as well before we could even really proceed with the department's own investigation.
And please tell His Honor the jury what his reaction
It was not good. He became angry. I remember a comment, something along the lines of telling the chief that he needs to learn how to do his job. And it got emotional pretty quickly. It surprised me, quite frankly.
Emotional on Sergeant Dodge's part?
Yes.
How did the chief react to being told that he needs to learn how to do his job by Sergeant Dodge?
The chief suggested that he leave because he was becoming insubordinate, at that point.
Objection, Your Honor. Move to strike.
Do you wish to be heard?
I disagree with the objection.
Do you wish to be heard at sidebar?
Sure.
Okay.
What is your reply?
I don't understand how this objection.
Number one, it's outside of the scope that counsel represented he was going to be asking about. Number two, it's a separate additional charge for which we've had no discovery. Insubordination is an offense under the code and under their rules and regulations. It's a legal conclusion by this witness, and his observation shouldn't conclude that a new offense arose out of this event. This is the first we've heard of this entire 7-year case.
The objection is overruled. I'll give the jury a limited instruction.
Ladies and gentlemen, the objection is overruled. The answer will stand. But the answer is not to be considered for the truth of the matter that indeed Lieutenant Dodge was actually being insubordinate, but simply to demonstrate what Chief Haig's state of mind was at that particular point in time. Next question, please.
Nobody charged him with insubordination, did they?
No.
Nothing else. Thank you, Chief.
Cross-examination.
Good afternoon, Chief.
Good afternoon.
Going back to 2014, the promotion in effect that was made on 2/28/2014 was Sergeant Westerling was Stephen Westerling to Sergeant, correct?
That sounds correct.
Okay. And it was made off a short list.
Potentially. I don't remember exactly who was on that list at that time.
There would have been 2 people on the list, Officer Ting and Officer Westerly. Would that be a short list, sir?
That would be, yes.
Okay. And so if he was promoted on 2/28/2014, that would have been a short list promotion.
Correct.
Okay. And he was promoted, is it your understanding he was promoted with less than 12 hours to go on that list?
I don't remember that specific information.
But Westerling is white.
Yes.
And subsequently, did the chief ever tell you he wanted to promote Pat Buchanan off the October list?
Objection.
What's the basis?
There was no October list.
I'm sorry?
There was no October list.
Why don't you rephrase your question?
You understand there was a list in the fall, correct?
Of 2014?
Correct.
Yes.
Okay. And it had Buchanan and Haskins in that order.
That's correct, I believe. I'm sorry, I haven't seen that.
Yep.
I didn't see that list in preparation for today. I wasn't.
Did Chief Haig ever tell you he wanted to promote Buchanan off that list?
Not that I remember, no.
Did he ever tell you that he went to the mayor's office and worked with the mayor to try and get Pat Buchanan promoted off that list?
Not that I remember, no.
Do you remember the chief saying to you any words to the effect that he thought Pat Buchanan was lazy?
Yes.
Okay. And that he didn't fit the bill?
I don't remember those exact words, but
Something to that effect?
something to that effect, yes.
Okay. And he didn't want to promote Buchanan.
I don't think he believed Buchanan was the best candidate.
And was the best candidate Jimmy O, who hadn't passed the test?
I'm not sure he was on the list.
Okay. But was he the chief's preferred candidate in the fall of 2014 timeframe?
Well, at the end of the process, he was selected. I can't speak to the chief's preferences.
Okay. And in 2014, Officer Road had been serving for a year or so as a provisional sergeant. That's correct?
That sounds correct, yes.
All right. Thank you, sir. Nothing further.
Attorney McDermott.
One moment, Your Honor. No questions for this witness, Your Honor.
Attorney Keston.
Yes, sir. In 2004, first let's get the timing right. In 2014,
I think it's 9.
Exhibit 9. You've seen something like this before?
I've seen it. Yes, this is a NeoGov document of the list.
And you see the date?
April 23rd, 2014.
And that's the short list that has Buchanan and Haskins on it, right?
Correct.
Okay. Road. Like that. In 2015, you recall there was a assessment center which produced candidates.
Yes, for sergeant, yes.
And that's when Road first came up.
Yes, on a list, yes.
Now let's talk about Patrick Buchanan. Did you, in 2014, did you think he was lazy?
Yes,
Why?
because he just lack of general productivity and call activity reports, general consensus from conversations with other supervisors seemed to be in agreement with that assessment.
Among all the supervisors,
Yes,
including Todd Dodge?
yes,
So in 2014, did Todd Dodge share his opinion with you that he thought Patrick Buchanan was lazy?
yes.
Objection, Your Honor. Move to strike.
Sustained. The answer is struck from the record.
Can I be heard?
Sure.
Okay, first on the objection.
We're outside the scope. He's of Tim's, Attorney Ryan's cross. This wasn't. I didn't ask any questions. He's now asking Dodge questions.
Okay, your response.
Attorney Ryan opened the door. He decided to go there.
We did. Okay, the objection is overruled. Right, the objection is overruled. The answer will stand.
Did Todd Dodge ever advocate promoting Buchanan to sergeant?
No,
Did he say words that indicated he didn't think he should be a sergeant?
yes,
Did you agree with the assessment based on your knowledge of Officer Buchanan that he was not a good candidate to be promoted to sergeant?
yes,
Nothing else.
Recross.
In preparation for your testimony, did you look at any documents, any memos, any notes from anyone in a supervisory capacity in the Greenfield Police Department at any time before January 1, 2015, to Officer Buchanan calling into question his productivity?
no.
And there are no such records, correct, sir?
That's maybe correct. I don't know.
You're not aware of any,
Correct.
and you never sent any.
No.
And as a deputy chief or as a sergeant, you never asked anyone to send any
No.
notes to Officer Buchanan about productivity.
Supervisors were asked numerous times to deal with productivity issues, but in terms of actual written documentation, I can't remember anything specific.
And in your years as a deputy chief, you never sent such documentation, correct?
To Officer Buchanan directly?
Yeah.
Correct.
Thank you, sir.
Attorney McDonough.
No questions for this witness, Your Honor.
Recross. Redirect.
Chief, was there any dissent from any supervisor in the Greenfield Police Department in 2014 that Officer Buchanan was not productive and was not fully doing his job?
I'm sorry, can you
Was there any
read?
dissent? Did anybody have a different opinion?
No.
Attorney Ryan.
No, Your Honor.
Attorney McDonough.
Briefly, Your Honor. So, are you saying that you went and polled all the supervisors in the fall of 2014? Is that your testimony under oath today, sir?
No, formally poll them. No, these conversations happen frequently, formally and informally, but actually poll people, I guess what's your definition of a poll?
Did you? Did you poll them?
No.
And there's nothing in writing to that effect, correct?
Correct.
Nothing further, Your Honor.
Attorney Keston.
Do you recall in 2020 there was a promotional process?
Check.
Sustained.
Excuse me?
Sustained. It's outside the scope.
Was there a poll of supervisors about Buchanan in 2020?
Objection, Your Honor.
It's a question he can answer.
Objection, Your Honor. Scope. My questioning was 2014.
Okay, sustained.
Nothing else.
All right. Who are we up to? Attorney Ryan.
No questions, Your Honor.
Attorney McDonough.
Nothing further, Your Honor.
Okay, you're excused. Thank you, sir.
Thank you.
Okay, you can call your next witness.
The defendant's called Robert Haig.
Okay, Chief Haig, you've been previously sworn in. You remain sworn in. Please have a seat.
Yes, sir. Chief, were there discussions in 2014 among you, the deputy, and at times then Sergeant Dodge, president of the union, about the mayor's refusal to hire a sergeant off the short list?
The refusal to promote off a short list in general, yes.
So we're clear, the mayor did promote Westerly.
Absolutely.
Can you tell you why?
He was partial to veterans.
And Todd Dodge, was Todd Dodge part of the discussions about the Westerling promotion?
I don't believe so.
Was Todd Dodge part of the discussions about what to do to get sergeants promoted if the mayor would not promote up the short list?
Yes, it was a general conversation.
Did Todd Dodge ever express his opinions in 2014 about the suitability of Patrick Buchanan to be a sergeant?
I don't recall anything specific.
Did Todd Dodge ever advocate for Patrick Buchanan and say he should make him a sergeant? Ever?
No, never.
Did Todd Dodge participate in the decision to go to the assessment center for the sergeant's promotion?
I don't think he was a decider, but he was certainly a participant in the conversations about moving to an assessment center.
That's the question. Were there conversations that he was participant of about moving to the assessment center?
Yes.
Did he ever say anything to you that he thought this was illegal?
No.
Did he support it?
Yes.
It was your decision to go to the assessment center. As of 2014, you started moving that way for sergeant. And the assessment center was held in the summer of 15. Do you recall that?
Yes,
Was your decision to do so motivated in any way by race?
absolutely not.
Did Patrick Buchanan have as much of an opportunity as anybody to score at the top of the assessment center?
Absolutely.
Were any of your decisions with regard to Patrick Buchanan related to his race?
Absolutely not.
Were any of your decisions, did Sergeant Dodge ever even hint to you that he was opposing something
Objection, Your
illegal?
Honor.
Sustained as to the form of the question.
Did Sergeant Dodge ever convey to you in any way, shape, or form that he thought anything you were doing was illegal or discriminatory?
No.
Nothing.
Cross-examination.
Good afternoon, Chief.
Good afternoon.
You'd agree Officer Buchanan didn't get the same progressive discipline that others received, correct?
No.
You'd agree that he did receive discipline, correct?
Yes, agree to that.
And you'd agree that Officer Dodge, then Sergeant Dodge, also received discipline, correct?
Yes.
And that each of those was on the first instance of substantiated disciplinary findings, correct?
I would agree to that.
And each of those were imposed by you,
No.
or recommended by you.
Which one?
With respect to Officer Buchanan, a 3-day suspension, unpaid, demotion from provisional sergeant, and removal as FTO.
That was me.
And with then Sergeant Dodge, 5 days maximum unsuspended pay, and following a period of admin leave. That was by you as well, correct?
No.
You placed him on your office placed him on administrative leave, correct?
Yes.
And also suspended him 5 days unpaid, correct?
No.
You recommended that he be placed for 5 days unsuspended, correct?
Unsuspended?
Excuse me.
Suspended? Yes, I did recommend to the mayor.
Unpaid suspension for 5 days, correct?
I recommended that, yes.
And that was also on a first instance of discipline, correct?
Correct.
And both of those disciplinary decisions ultimately were vacated by independent external arbitrators who reviewed them.
Asked and answered.
Overruled.
What part of it vacated, sir?
Each of those disciplinary outcomes that we just talked about were vacated by different independent external arbitrators reviewing those disciplinary outcomes. Correct, sir?
The suspensions were overturned. The discipline was not.
I'm talking about the suspensions.
Thank you for being specific. Yes, the suspensions were overturned by the arbitrator.
Thank you.
Attorney Ryan.
No question, Your Honor.
Attorney Keston.
The defendant's rest.
You have no questions then?
No, sir.
Okay, you can step down.
Thanks.
All right. Very well. Ladies and gentlemen, the defendants have rested. That concludes the formal presentation of evidence to you in this case. There are a number of matters that will require my spending a significant period of time with the lawyers and then on my own while I draft up the jury charge. Before I give you the jury charge, you'll be hearing closing arguments from counsel. I went through the anticipated schedule, at least in terms of the different steps that lay ahead with you yesterday, so I'm not going to repeat it. But I'm going to let you go for the day today. And that is because we're nearing 1 o'clock or so, and I'll give counsel obviously an hour for their lunch break. And thereafter, I need to meet with them for probably an hour or so. That will take us to about 3 o'clock. And then I need to go and draft up my jury charge. That will take me a number of hours. I'm going to let you go tomorrow. We're beginning a little bit late because of some scheduling issues. I'm going to bring you in at 11:30 in the morning, and you're going to hear closing arguments of counsel, which will take 1.5 hours. Okay, so that will take us to 1 o'clock. I'm not going to give you your jury charge tomorrow. I'm going to give it to you on Monday morning. And that is because that in the best case scenario, and as we've seen, there are many unforeseen delays that might occur through no one's fault. My concern is that even were I to charge you tomorrow, you'll have a nominal amount of time to deliberate, and then I will see you next on Monday the 2nd. It is a better course of action for me to give you my jury instruction, which again takes about an hour and 15, an hour and 20 minutes or so, and then have you go off and start your deliberations. We do request that you deliberate a full day, which generally goes to around 4:15 or so, starting on Monday. Okay, would counsel like to be seen at sidebar?
Yes, sir.
Procedurally, I just want to review our motions for director.
Yeah,
At the close of the evidence, I just want to preserve it.
I haven't forgotten that. We'll address that as soon as I see them when they work. Okay.
All right. Ladies and gentlemen, having said that, and with the ongoing instruction not to discuss the case with anyone, including amongst yourselves or anyone else, I'll look forward to, nor to do any investigation or research or look at any media reports in this particular case. I'll look forward to greeting you here tomorrow at 11:30. Okay? Have a great day. Thank you.
Bye, sir.
Okay. Now I'm happy to hear from counsel on your renewed motion, but bear with me a brief moment, please. Okay, Attorney Keston.
Your Honor, I've made the argument with regard to Lieutenant Dodge. We have filed papers on the other ones. Mr. Lyon, I anticipate is going to call an opposition. That would be the time we should argue it, my suggestion.
All right. You are going to be filing an opposition then by, I guess, when? This is going to upset our schedule, I'll tell you that. And I don't require a written opposition. I mean, it's your choice. I'm not asking for one.
My jury instructions in many ways set forth the law, and
I don't accept proposed jury instructions as an opposition to a motion for directed verdict.
Your Honor, if I'm going to submit a written opposition, I won't be able to get it in. It's 1 o'clock now till 8 o'clock in the morning.
Right.
We never had any motions, dispositive motions in this case.
All right. What we can do is this. As I say, I'm not asking for a written opposition. If you want to file one to preserve your rights or for whatever reason, that's fine. But I'm still going to do our jury charge conference since you're all here, and I'm not going to, set us off. So you're to file and serve. You can have it till 11:30. I won't be here until then. So nor will count. Well, I'll be here before then, but counsel won't be here until around 11 o'clock, I suppose. All right. So I'm going to continue hearing on the renewed motion for directed verdict to tomorrow at 11:30. So we have to stop. We have a hard stop at 3:20 p.m. tomorrow. okay? Just so you understand. I don't think that we'll be here at that hour, but just to let you know, that's a hard stop. Okay, let's turn to our charge conference. One moment, please. Okay, I'll be right back. I just need to get your. Okay. Attorney Ryan, I'll hear from you on your request for jury instructions.
Your Honor, we submitted our request. The burden of proof, I think it's relatively straightforward, which is pages 1 and 2. And then pages 3, we get into motive, intent, state of mind, which are relevant to proof of discrimination or discriminatory discrimination in a case largely involving direct evidence. So we've got direct evidence, we explained it. We've got circumstantial evidence, unexamined bias, the attributable bias.
Let's talk about attributable bias. That's one of the issues in this case that relates to Sergeant McCarthy. The case law, at least it doesn't appear to me, to directly address whether or not a supervisor has to be, in this particular instance, Mr. Buchanan's supervisor. The defendants maintained that Sergeant McCarthy was not Mr. Buchanan's supervisor, and therefore there should be no attributable bias as it relates to Sergeant McCarthy, or in general, I suppose. What authority can you point me to that settles the issue that when the cases identify a supervisor, it could be anyone in a supervisory capacity, not necessarily the employee supervisor?
Your Honor, on that, I mean, the appointing authority is the mayor. And so I would argue that the attributable bias is to everyone within the department, that he's lazy. Chief Williams just indicated that he's lazy, doesn't fit the bill. Certainly the evidence from Sergeant Dodge is very clear that that's what happened. The evidence from McCarthy's own bias, which started in root, the investigatory internal investigation, which resulted in the suspension, the demotion, etc. All of this flows from a department, Your Honor, where you have this bias, which is throughout, and it's attributable to the members. And they are not the actual persons making the promotion. They're just, recommending up the chain to the mayor and to the public safety committee who it is that should be promoted. So I think the attributable bias, Your Honor, is everybody within that department, and the flag is just one element of that.
Okay, my question relates to legal authority for your claim. Attorney, we're going to address this particular issue, and I'll go across the board. Attorney McDonough, your argument relative to attributable bias.
I don't have the cases committed to memory on this topic, but I am fairly certain I could supplement that it's really any leader. And here it's not just any
sorry,
leader,
it's really what?
any leader in the organization. And in this case, Your Honor, this is not just some random supervisor. It is someone who carried the baton from the mother of the driver to the mayor. And frankly, it's the first time the baton goes from the mother to Clark to McCarthy. And it's that point that it turns from a positive baton into a negative one. And so this is in particular, he is in the chain reporting this alleged disciplinary issue up. And that is actually when it flips from a positive to a negative. I can look more closely at the cases upon which we've each requested this. But I believe that in Bulwer this came up. And I believe
Bulwer does not specify whether or not it is Bulwer, I believe, is the case in which it says a supervisor, and I think in that particular case it was the employee's supervisor. One moment. I've got Bulwer here. Hold on. So in Bulwer, where the decision makers relied on the recommendation. This is Bulwer at 688. Where the decision makers relied on the recommendations of supervisors, the motives of the supervisors should be treated as the motives for the decision. And then it goes on to cite that an employer may not insulate its decision by imposing an intermediate level of persons, citing the Forbes Library case and Cariglia, the federal case, the First Circuit case. But I'm not convinced that Bulwer really clarifies whether or not it has to be the employee's supervisor. That's not to say that it can't be just any supervisor. So can you provide me with some, and actually this is the charge conference, and I am going to be drafting this up, and this is a central issue in this case. So what can you give me?
I can give you in the case you just cited, there's nothing magical about the person being a supervisor. If the decision maker's decision is based on a recommendation of someone being biased, why does it matter if that person is or is not the person's supervisor? I don't see how that's a
Well,
keystone.
Bulwer does specifically refer to supervisors.
It happened to be supervisors in that case. But if they're relying upon a biased report from someone in the chain, I don't understand logically why whether or not that person is a supervisor removes or covers the bias. It's the reliance that's central. And I think there is more on this topic. That if I just had a minute, Your Honor, I do think that.
Well, there'll be a lunch break rather soon, and so you could take a look at it over the lunch break.
Thank
So,
you.
actually, why don't we let's take lunch now? Then I'll return to Attorney McDonough. Then I'll turn to Attorney
Can I
Keston.
make one comment?
Sure.
He has no standing to argue.
Yes, I do.
He represents Dodge. Dodge has nothing to do with this. Dodge is strictly whistleblower.
Okay. All right.
So I don't understand how he gets to argue on behalf of Buchanan.
I absolutely get to argue on behalf of Dodge, and it's the same issue.
Yes.
No.
My client stood
Right.
up for someone.
I'm satisfied that Lieutenant Dodge's claim derives from Mr. Buchanan's case, so he's got standing. All right, I'll see you all at 2 o'clock. Thank you. Okay, so we were talking about attributable bias. I posed a question, and we're not going to belabor many of these points because we do need to report. What I may do, depending on how this conversation goes, this jury charge conference, I may have the clerk's office contact the jurors and tell them that I will not see them here tomorrow if this bleeds over until tomorrow, because it just won't be possible to pull this all together, and that I'll see them on Monday morning. But we'll see how we do. Because after I conduct this jury charge conference, I have several hours worth of work that I need to do, and if we go to 4:30, then I don't know how we're going to do this first thing in the morning and get you a draft in time that you can prepare your closing arguments, because you also have to read the jury charge before your closing arguments. Okay? Having said that, just one further question for you, Attorney McDonough, then I'll turn to Attorney Keston on this issue of attributable bias. I had inquired of Attorney Ryan and you and all of you what authority you can give me, mindful of the Bulwer case and the other cases that have been cited, that the supervisor has to be the supervisor of the employee as opposed to a supervisor, and Bulwer refers to a supervisor. So I don't know that I'm going to read into that it means the supervisor for the employee, but I'm looking for some legal authority, please.
That's correct. Well, first, Bulwer, a supervisor would mean the equivalent of any superior person to the plaintiff, but also I believe the court cited Corriglia.
Right, to the plaintiff. They were both, so I guess here I've got a provisional sergeant and a sergeant. There's no evidence that one is senior to the other, so happy to hear from you in that regard as well.
Okay, well, I would just submit that I believe it was testified to that the formal one is superior, but
what is the testimony in that regard, please?
That once someone is that a provisional sergeant, for instance, can be demoted back down much more hastily than a full-on promoted sergeant, official sergeant.
But what evidence is there that a permanent sergeant supervises a provisional sergeant?
I think that the chain of command in a law enforcement office, the rank structure itself provides that any superior rank can.
Okay, let's move on then. Attorney Keston, just on this one.
I'm sorry. My main point, Your Honor, was that there is a case that addresses the underlying issue of whether the person with the animus need be a supervisor at all.
What is the case?
That would be the language in Corriglia versus Hertz.
Right, and that actually is probably, I think, from your perspective, the most helpful case. Let me take a look at that. That's the First Circuit.
Sure.
Hold on. One moment, please. So this kind of dovetails. This is all around pages
86, Your Honor.
Just a brief moment. I don't know that I have the page number, but 85 to 86 to 87. That's what you're referring to, right?
That's right, Your Honor.
Okay. I appreciate that, and I've read it, and I understand why you would maintain that is important. I'll take another look at it, okay?
Thank you, Your Honor.
All right, thank you. Attorney Keston, just on this one issue, attributable bias, please.
Okay, but all three point.
I'm sorry?
Not just, yes, so there's three things. There's a number of things they have to get to before they can get this theory off the ground. One is, yes, there has to be a supervisory action of somebody that's a higher position than the plaintiff. And here they're both sergeants. There is no evidence of any sort that they're of different ranks. They're both sergeants. Number two is the person to whom you want to attribute the bias. The person whose bias you want to attribute. In this case, they want to attribute McCarthy's alleged bias to Haig. That person has to be given materially false information and not look into it. In this case, they were given true information and conducted an investigation, which ends the inquiry. The investigation proved that everything McCarthy said was true and more. The difference they can point to is that McCarthy said that Clark told him there were 5 prior instances, and the investigation proved there were 10. So the only way this cat spot theory works is that the supervisor, the lower level supervisor, gives false information to the upper level supervisor who doesn't look at it and just acts on it. In that case, they might be liable. In this case, none of that is present. McCarthy is not a supervisor. The information he gave is factually accurate. The town, the city, the town, and the chief did not act based on McCarthy's accusation at all, actually. They started an investigation, and that's what they acted on. So there cannot be, which means the flag's gone.
All right, and I appreciate your bringing up the issue relative to the factual content or lack thereof, in this case of Sergeant McCarthy's representation. And I do want to ask you what your response is in that regard.
Specifically, which, Your Honor?
Well, there's in order to establish attributable bias, there are different requirements. One has to be that the individual, in this case, ostensibly Sergeant McCarthy, gave, and I think the language is materially false information. And so what is the materially false information? And bear with me a brief moment while I just get this in front of me. Hold on. Here it is.
Yes, exhibit 2. No, tab 2. Sorry, I do that every time.
Okay. Right. So that the case law establishes that, and the requested charge on attributable bias is that you may find discrimination when the adverse employment decision is made by an individual who is without discriminatory animus, but who relies, okay, so this would be Chief Hague is without discriminatory animus, but relies, meaning on ostensibly Sergeant McCarthy, on the false or misleading information provided by a supervisor. So what is that false or misleading information? And in that regard, hey, Harry, do me a favor. I've got that big binder right on my table. Do you mind getting it for me?
Exhibit 1, tab 2, Your Honor.
All right, just a moment. Because my inquiry was whether or not the articulation of there were 4 or 5 prior incidences was materially false. But as I recall, and Attorney Keston has stated, it was inaccurate, but actually it was worse, at least according to the evidence. So I'm not quite certain that that fits within the notion of materially false. And this is only on whether I'm giving the charge an attributable bias. And thanks, I really appreciate that. You said tab 2?
Tab 2 is the letter, Your Honor. Tab 3 is the report.
Right, tab 3 is the very beginning. Oh, tab 2 is the letter. That's what I want to see. Right.
The letter is false, Your Honor, because he says, I did not find this a problem until this officer, Detective Clark, said this is the 4th or 5th time he has heard Buchanan made these type of stipulations.
Right, so that's my question is whether or not that is false. Attorney Keston says, well, it's not really false, although it might be false if it's really 10 or more prior incidents. But what is false? What was the evidence that that statement was false?
The evidence that that's false is on page 1 of the narrative report at tab 3.
Okay, wait. Page 1 of the narrative, so that's, yep,
If we go down to
I got it. What paragraph?
it's the 4th paragraph. I met 121:15. I met with Detective Clark.
Okay, bear with me a moment. Okay, so how does this render the statement in the letter false?
Because he said that Clark spoke of 4 or 5 prior incidents. Here, Clark says he knows of 1 prior incident.
Oh, okay, hold on a second here. Which line are we at?
It'd be 3 or 4 lines from the bottom, beginning Detective
Okay,
Clark.
Detective Clark told me that he did remember reporting. Oh, it's cut off. So that
One other similar incident.
Okay, so that's your allegation. That's your allegation. Okay. All right, bear with me a brief moment, please. Hold on. Okay, I'm going to move us forward.
Just on that one last point, Your Honor, recall that there was no information provided to Mayor Wettengartner on the second promotions, and it's unclear as to what information was provided to Mayor Martin on the first promotion through Chief Haig.
Yeah.
And so we'd suggest that that is also attributional.
Okay, I'm moving this forward.
Well, there's another level where Haig is the one with the racial animus. We have evidence that it's him, and it's attributable up to the mayor by filtering in a disparate fashion.
Okay, all right. One moment, please. All right. The reason I need to move us forward, so I do that with all due respect. If I'm not trying to cut people off, okay, I'm trying to be efficient. And I apologize if anyone here thinks that I have cut them off, okay? I will cut off people if they're doing something that's inappropriate, okay? But my intention is always to be efficient. Yes, Attorney Kasten.
10 seconds. The chain is broken in this business of
Right.
McCarthy's letter because they looked into it. You have to rely on it to act.
I understand. And,
At the end of the inquiry.
I understand. And there's a distinction to be drawn between ultimately what I do with motions for directed verdict on legal issues, okay, which I probably reserve until after the jury comes back with a verdict, which should come as no big surprise to anyone here, or on a motion for new trial, and what I charge a jury on, okay? So I hope that you can all appreciate that. Because as I move forward, the biggest issues relate to Lieutenant Dodge. And so I want to move us forward so we can get to those more complicated issues, okay? So having said all that, where was I? Oh, tangent to attributable bias is the general atmosphere of discrimination, which goes to the issue of the Confederate flag. Why don't I hear from you in that regard, Attorney Ryan? That's you're at page 7.
So, Your Honor, we're looking for this instruction of that general evidence of discrimination. We have in this case, while he was working there, 2 chiefs, former chiefs, using the N-word at various occasions. We have
Well, I understand the evidence is there. I guess my question, I should have more artfully phrased it, is what is the legal authority that would permit me to give this instruction in this case? I get the fact that there is evidence out there. Okay, so what is the legal authority, please?
Your Honor, we cited the Doms versus Cognitz case and the other cases.
And can you tell me a little bit about those cases, or at least one of those cases?
Well, Doms, actually, Your Honor, I believe it was, I forget if it was a summary judgment, but that was a sex harassment case where there was back and forth, back and forth, back and forth. And so the whole evidence of the workplace went in.
But was that a hostile work environment case?
It was a...
Because I do recall looking at it, and I think it was.
No, at one point, Your Honor, I think it was a consensual relationship that fell apart. And then it became kind of retaliation. And
no, but my question relates to the claims presented in the case. Okay, so certainly in a hostile work environment case, one would expect to probably see this charge. Okay, but this has not been pled as a hostile work environment, so to speak, case. So why should I give this charge?
And that I don't think was a hostile work environment. I think it was a failed relationship, Your Honor. Retaliation springing from a failed relationship, as I recall. Doms and a supervisor had a relationship. They were in Japan. It fell apart. That's how I recall the facts of that case, Your Honor. And then it was the retaliation after she made a complaint. That was the evidence. And here we have the evidence of an ongoing work environment that lasted, for 20, 21 years.
Okay, very well, thank you. Do you wish to be heard in this regard? I don't know that you have too much to say there.
No,
but, okay. Attorney Keston, I catch your heft. I'm disinclined to give this instruction.
Of course, if they filed a hostile work environment, that's what that relates
Yeah.
to. This is not a hostile work environment case. And plus, the evidence of rumors about those chiefs or those officers saying something cannot go in for the truth of it. They went in for the rumor. So the fact that somebody says I heard a rumor about it is hardly something that they can hang their hat on. And it's got nothing to do with this case.
The facts of this case, Paul, significantly far afield of those in other cases where it'd be put in to give this instruction. I'll tell you right now, I'm not giving this instruction. Okay. Attitudes of those in authority. I'm just not quite sure. Let me see something here.
What page is that?
It's on page 8. Your Honor, I'm not sure that there's any specific remark that would fall under that.
Okay, so you're withdrawing that, right? Conduct and remarks that support an inference of discriminatory bias. And these fall, that one and subjective criteria, these sort of, those fall within the model, but I don't think I need to hear from either of you in those regards. Failure to follow policy or guidelines, okay? I think that's part of the heart of your case. Is that fair to say?
Yes, Your Honor.
Do you wish to be heard in that regard, Attorney Keston?
Not at this point.
Okay, thank you. Failure to follow the law, that's obviously at the heart of your case. Statistics.
I'm not sure it's really relevant because there's no statistical evidence to prove discrimination. It's just...
Yeah, I mean, there was no statistics relative to a general pattern of discrimination. There were other stats, but not that. That comes out.
Yes, there were stats supporting is not being promoted.
Do you want this in?
No,
Oh, yeah.
I'm sorry.
Right,
It was a
right.
wise remark. I apologize. No, of course not.
Business-
This is not a hiring case.
Business judgment, you've all asked for that. I'm going to give some version of that. So, the first sentence on your totality of the evidence, I don't know where that comes from. So, and let me just tell you, in general, I stray away from, unlike many other judges, but I stray away from my somehow praising or representing what the facts of this case are. I just don't do that because I don't want to mischaracterize anything, okay? So I don't do that because that is to say you're not to infer that my not doing so is a reflection on the bona fides of your claims. I just don't like doing that. Here, relative to your suggestion as to what the most productive means of establishing suspension was, I'm not going to say that. Okay, there is more generalized discussion, and here I really, hark to the model instruction as much as possible. Bear with me this moment, please. Yeah, the model has discussion relative to circumstantial evidence, and I pretty much will align myself with that. This Confederate flag, that's just not coming in. It's just not a jury charge, so I hope you can respect that. So that's not going to be a mixed motive. Let's talk about that. In order to, a couple of notes in this regard. I think that there's going to be an objection to the mixed motive instruction. Right.
You know something, Your Honor, we have to check ours, we may have our own.
While you're looking, it's appropriate when Mr. Buchanan, in this case, has proven by preponderance of the evidence that an illegitimate reason played a motivating part in challenging an employment decision. And so the model instruction sets that forth as a springboard, so there needs to be that preliminary determination before they get to the mixed motive. Before I dive into that, is there going to be an objection to, I don't know them, let's see what yours is. If yours looks like the model.
I believe that's what Ms. Brody used.
Okay, so it seems to me that this, it seems to me that this is a mixed motive case. Okay.
Do you know what number that is, Your Honor? The mixed motive, our mixed motive.
Yours?
Yeah.
Bear with me a moment. Okay. Bear with me a moment. Yes, you're page 15, and yours is the model.
Ours is 15?
Page 15, yeah. So that'll say it, as it should. This is a mixed motive case. Okay.
Yes.
Now turning to retaliation for Mr. Buchanan. And it seems to me that your language pretty neatly tracks the model.
I believe so, Your Honor.
And let me just say here, I've drafted something up which is based upon the model.
Yes.
And so ultimately what you see may not have all that you have included, and I'll hear from you on that. Ordinarily the way I run these charge conferences, which is not what I've done in this case because I don't think it would be efficient, was to give you my draft and then work off of that. But I just can't do that in this
Your
case.
Honor, we would accept the model.
All right, let's move forward.
It would be R15, but we'll accept the model.
And then there's, adverse employment defined, retaliation in temporal proximity. You've all asked for that. Damages, back pay, emotional distress, punitive damages. Is there going to be a quarrel relative to damages, or I shouldn't say quarrel, excuse me, a disagreement? They're straight out of the model.
Oh, damages? No, we're going to object to any instruction of punitives.
Okay, let's talk about that. why don't I hear from you first relative to why I should give an instruction on punitive damages, and I'll hear from Attorney Keston.
Your Honor, it's our position that this case fits fully within the outline of the Haddad case. It's a race case. It's a long-standing race case. Ongoing acts of discrimination, ongoing acts accumulating in the fact that even when he was the last guy on the list, they went around him. And they didn't tell the decision maker they were going around him. And the decision maker just ratified the 4 names put in front of her without understanding where and when and how all of these people, all the candidates ranked. The fact that, the differential treatment, again, the mayor didn't see the ranking until she was here. The former mayor didn't see the evidence as to Clark until he was at his deposition. So they run this department kind of as their own operation, shielding relevant, important information from decision makers. And in the process, they've again and again and again denied Patrick Buchanan a promotion that we submit he was entitled to.
Okay, thank you. Attorney Keston.
Your Honor, the facts of this case do not support punitive damages either against the city or against Chief Hague. We had a number of hiring processes that happened. I mean, that's why they're trying to go for it implicit, or somehow they even tried to get you to accept that even if he doesn't know he's discriminating, he is. The evidence does not support any conscious discrimination by any member of the Greenfield Police Department or the city, or the mayor or the city. This is not a punitive damages case. They're down to one alleged comment that Todd Dodge comes up with, in which there's evidence that he shared an opinion, and from that we're supposed to pick all that up. And I just don't see this as that kind of case.
Your Honor, I don't think there's a punitive damage claim that could be brought against the chief. We're certainly not alleging it. I think it's only against the employer, not the supervisor.
Well, good to know. So you're dropping your claims.
We're dropping. I don't think as a matter of law you can ask for punitives against an individual, Your Honor.
I'm happy to accept that representation on behalf of Chief Hague. Then I don't think there certainly can't be one against the city based on this.
Okay, so
He's the actor.
I understand. So you're, okay, very well. So the punitive damages are being asserted only against the city, not Chief Hague. And it seemed to me that was perhaps understood by some, including myself. But mitigation of damages, you're both requesting, I think, what is fairly close to the model on mitigation of damages. Anyone wish to be heard in that regard?
So this is a back pay case.
I didn't,
How does mitigation?
They.
I know, and me too.
Well, you both, okay. I'm only the judge. You both requested this. There can, I think it's a tortured analysis in my mind. Let me just tell you, because when I saw this, particularly when I saw it from plaintiffs, it didn't make sense to me.
Your Honor, based on your ruling, we concede there's no front pay calculation in this case. And so we'll withdraw.
Okay.
Yeah.
Okay, and you're withdrawing yours.
Yes, Your Honor.
Thank you for making me scratch my head as to what I was missing here. Okay, thank you. Emotional distress, I think that this was pretty garden variety. And then there's a discussion of punitives that I will look at. Initially I'll admit I had some confusion because I had Mr. Dodge's, I had a transmittal saying that attached, please find Mr. Buchanan's model proposed, jury charge that included a jury charge for Mr. Dodge, which seemed to me to be, with all due respect, not as fulsome as what I would have expected. That's why I requested one, because I thought that I was missing one. I'm not going to turn to Lieutenant Dodge yet, okay? because what I want to do is I want to take a look at Attorney Keston's jury charge, which I
Attorney
think
Brody's jury charge on it, to be clear, she did all the work.
I'm sure she did.
So I just want to.
It's Attorney, I was actually going to address Attorney Keston's charge first because it's just a lot easier because there's less in it, and what's in it is probably less subject to discussion. But I do want to just focus on Mr. Buchanan in relation to the defendants. So we're going to turn now to the defendants, and then we're going to come back and address Mr. Dodge, which I'm still trying to get my mind around. Okay, so defendants, one moment, please. Oh, you both had tucked into yours this burden shifting instruction, which the SJC, in which case was it, Lifshitz versus Raytheon, really cautioned against. And, we do it on summary judgment, but it's just not good.
Your Honor, I completely agree.
All right, so that's going to come out.
With it. We should not have it. And also, one of my many pet peeves is when we say that the plaintiff's privilege is a member of a protected class. We're all protected. But yes, so we should not have burden shifting. It should just
Right,
be
okay, so
burdens
that-
on the plaintiff.
Yeah, that's coming out. Okay, so thank you. All right, bear with me a brief moment, please. Actually, while I'm still on Mr. Buchanan, let's take a look at these supplementals. Unlawful sick time retaliation. There's been no claim asserted under the statute. How's that coming in? Or I should more politely say, are you moving forward on that?
No, Your Honor.
All right, so that's out. Although it was a good try.
Well, I don't think so.
I'm being polite.
As you know, I'm not.
No. Let me just say this. Attorney Keston,
Yes, sir.
I apologize. Okay?
Your Honor, I was going to do it. Did you had the
Okay.
right to. I lost my cool. I'm sorry.
I'm a pretty uptight judge. Okay? I really like law and order in the courtroom. You're all great lawyers. Okay? Especially that Attorney Keston.
Thank you. Glad that's on the record.
This has been very hard fought litigation. I'm just coming from another very hard fought piece of litigation. And I have a day off from this, and I'm going back into another 3-4 week trial. So I apologize if I've been just a bit frazzled. Okay? So judges get overworked, they get stressed out, and I apologize, and I will, during my jury charge, make it known to the jury that any admonitions that I have made, albeit highly deserved, are not to pay any heed, and they don't. I do believe that I've been very even-handed in my rulings. I don't think anyone here is happy with my rulings, only because they have been, I think, pretty even-handed. But I do apologize to you, sir. I think that you're certainly a highly, highly respected member of the bar. It's a pleasure to have you in court. So with that, we're going to continue on. Okay?
I just want you to know that before you said this, my plan was, when you're finished, to apologize. I know I was. Yes, it's highly contested. I'm very invested in Chief Segg's issues he's suffered, and it infects everything, and these kind of cases are hard.
Let me say this.
It's hard for everybody. It's hard for the lawyers. It's
Your party's not here, Part of my frustration is in watching this department being torn apart. Okay? I sit in Greenfield. I don't know these police officers at all. I have a fondness for Greenfield. I don't live there. But this is really, really terrible stuff at so many levels. And that's part of my frustration, that, yeah, I get it. someone doesn't want to pay a certain dollar value, doesn't want to concede something, which is why I so dutifully, I believe, impressed upon everyone the importance of a confidential resolution, whatever that meant, okay? And I'm not even going there, okay? But I just want you to understand that that is probably the prominent feature of my frustration with this case, is that the fallout on this case will bear scars for a long, long time to a very important government body which is charged with public safety. And it has nothing to do with the lawyers here, okay? It truly doesn't, because I respect that decisions aren't made by lawyers. They're made by parties, okay? So I don't look at any of you in that regard. But I just want to offer that as just a glimpse into why I have been frustrated. The timing on the case is another issue, but that happens. I respect that. And I'm not trying to threaten anyone by telling you that your next trial is on October 23rd. That's actually the truth. It's a big problem. It's a huge problem here. I physically can't give you a date earlier. All right, I appreciate your understanding. Let's move forward. Plaintiff's supplemental request regarding qualified handicapped individuals. And so here, this goes back to the alcoholism issue. Are you going to move forward with this?
Yes, Your Honor. We're looking for some instruction. I mean, they're arguing that he was immune, or they couldn't take action because of the EAP program, and which we submit is an incorrect statement of the law. And if somebody who's a qualified handicapped person engages in misconduct, the law does permit.
The problem with this is that there's been no evidential foundation for me to give this. There is law, but the law doesn't just exist in a vacuum. There needs to be some evidence for me to charge a jury so that they can then apply the facts as they find them to be to the law, okay? Unless, is there going to be an objection to this charge?
Very much.
Right, okay. I'm not going to give it because there's no evidential foundation for this, okay? So I'm going to move us forward. There are bounds of permissible closing argument that you might find something to attach to in that regard, but there's been no evidence to support this, and I'm not going to give it in the way that it's cast, or probably in any other way. All right, now I can turn to defendants' proposed jury instructions, which, as I say, as to at least Mr. Buchanan, I think are far less controversial. I'm going to tell you that if you will look at the charge, request number 1, summary of contentions, that's something I told you I just don't do that. Number 2, in some form or another, and please tell me if there's going to be an objection, Attorney Ryan. As to page 4, I see nothing wrong. Page 5, this is boilerplate. Page 6, definition of adverse employment action, something like that will come in. Page 7, definition of similarly situated, that's fine. Employer's right, yes.
I think on adverse employment action, I think we can concede. They don't need to find it I'll just give it. He got disciplined, I suppose that could be. But something it's safer to give it the way it is. I withdraw my comment.
All right, thank you. Employer's right to manage employees. I have this. This is pretty much Hornbook. Is there any objection to that?
No, Your Honor.
Okay, that'll come in. Retaliation elements. That's page 9. That was fine. Unfairness is not necessarily retaliation. I have a similar comment. I think I put in this whole business about shabbily or unfairly because I did check the Weber case, but not verbatim what you had here. Is going to be any objection to request number 8?
No, Your Honor.
Then number 9, this kind of dovetails where you all have this business judgment, which I have incorporated in my draft. So let me say this. I've got something similar to this, but it probably isn't exactly what you have. I'll hear from you further once you see it. Okay? This next one, non-discriminatory reason, this is the burden shifting, okay, that I discussed earlier. That's the Wheeler College case, so that's out. Retaliation, this is almost verbatim the same as Attorney Ryan's. That's page 13, page 14. Page 15, we're back to business judgment, which was the same as his earlier. Determinative causes, page 16, that was fine. Okay, then we get into Lieutenant Dodge. So just to wrap up for a brief moment with Mr. Buchanan, is there anything further that you wish to say on your behalf, mindful of what I've just stated?
I'm sorry, read it on.
Okay, thank you. Okay.
Maybe it's good. Is it okay?
Yeah. Okay. Now we get to the hard stuff. Mr. Dodge, bear with me a moment. And we're going to deal with the special questions separately. I will do those last. Okay, so as I understand, Attorney McDonough, and I appreciate your opposition, which really helped me think about the jury charge and where you were coming from, because it wasn't clear to me what bases you were moving forward on, and there are technical requirements as to all of them. So I understand you're looking to move forward on 1, 2, and 3.
Yes, Your Honor.
Okay. And each in different regards, so bear with me a brief moment. Here you are. Okay, I'm looking at yours now. And I've got the model, which we did under our plain English jury instruction committee. So the elements of the whistleblower action, this is, I guess, page 2. Once again, here, these are facts of the case. You can argue that. I'm not going to say that. The elements of the whistleblower case, which is page 3. That's one short paragraph that identifies the elements. And then page 4 identifies what the protected activities are. Okay. So the first paragraph is pretty much from Christo. Is there any objection? I'm talking now about this is just the articulation of the statute. Okay. Mindful that we need to talk about whether or not I'm going to instruct on all 3 of these. Okay. And I'll dive into that a little more deeply. But in terms of the articulation of what the relevant prongs are, so to speak, I'm going to give something in that regard. I may not be instructing in all 3, though. Okay. You have something here, this last paragraph, about the mass whistleblower law being construed liberally. I'll hear from you on that. I just have not seen these cases before, and I haven't had a chance to. Oh, it's Edwards, which I just got. And I apologize, I hadn't yet read Edwards. But wanted to hear from you in that regard relative to the last paragraph on page 5. Then I'll hear from Attorney Keston just as to that particular paragraph, and then I want to dive into which of these sections of Chapter 185 actually pertain to this case. So, relative to Edwards and that last paragraph, please.
Roger, Your Honor. It's The Edwards citation, there's a couple sentences or half paragraph in Edwards where they talk about how these three different types of protected activities are going to often overlap. So, for instance, participation in a hearing is often going to include a disclosure, or an objection might include a refusal, and so forth. So that's why this liberal construction of these three ways to violate the statute is applied in Massachusetts, and that's the SJC in Edwards from last October. And then the other citations are obviously non-binding citations. They're persuasive, where other states have whistleblower statutes. I haven't found one that construes them strictly. They're all remedial statutes that are construed to embrace allowing an allegation of a claim rather than to foreclose a whistleblower.
All right. All right. Just in that singular regard, before we dive into the separate paragraphs of Chapter 185, Attorney Keston, I'm listening.
I see no evidence that the word liberal is anywhere.
I'm sorry, what?
That the word liberal appears in any of these cases. It must be liberally construed. I don't see it.
I guess that was my concern.
They're making it up.
I will look at Edwards, but I didn't think that there was anything. If you could point it to me, that would be helpful. Bear with me a brief moment.
No, I'm not making it up, as Attorney Keston claims. However, the word liberal is correct. It's not in the Edwards case. That's
okay.
It's the other jurisdictions that use the words. The remedial statutes are to be liberally construed.
That was just my understanding, without having done the research, that I've never seen anyone refer to a liberal construction of the whistleblower statute. It actually, to the contrary, I think it's a very technical construction. And that was my knee-jerking no to this request. So I will take a look at Edwards, okay? Okay. Let's talk about as to, first I want to talk about outside public body. Do you maintain that the mayor's office is an outside public body?
Yes, Your Honor.
Interesting. Okay. I take it you do.
Your Honor, the basic problem with this is filing a grievance cannot be.
Cannot be what?
Subject to the whistleblower law.
Oh, I understand. Okay, yeah.
That's the problem. Is it going to be for the jury to decide whether filing a grievance is a whistleblower? But of course it's not an outside public body. It's the mayor. It's all in the chain of command.
Okay, that's okay. And I appreciate your comment. Okay. I'm building to that. Okay. That's why I say this is, complicated stuff.
It is.
When we look at the Worcester case, so in that case, I guess she was in the sheriff's department and she didn't have to, she made a complaint to the sheriff's department. So it wasn't an outside body, because my read on the whistleblower statute, and this gets to the written notice requirement, okay, which is a completely separate issue. Because if the entity is an outside public body, then there needs to be a written notice. If it is not a outside body, then there need not be a written notice, which is one of the reasons why I'm just a little confused as to why you would maintain that the mayor is an outside body. And here, I haven't found any case law on point here. But it seems to me that the mayor is the appointing authority, okay? And while I guess technically he might be in the mayor's office and not in the police department, in the context of this case, there is a chain of command, as has been suggested. This actually makes your claim a little easier, to be candid, because if there is an outside public authority, there is a written requirement. If he's not an outside public requirement, there is none. Having said that, and we could park that on a shelf for a brief moment, that then dovetails with the issue of whether or not a grievance is protected activity. Okay? And here, let me just go back to what I said earlier, and which is that I'm fairly well settled that these issues are going to go to the jury, okay? And that maybe not all of the different prongs of the whistleblower statute, but and that some of these issues may have to be worked out at a later date, okay? But nothing is jumping off the page to me that says that some of these issues can't be questions of fact as to whether or not something is an objection, okay, under the statute, whether or not a grievance, for example, is an objection. So, having said what I just said, what is your position? Is your position the same that the mayor is an outside public body? Because that then is going to determine whether or not there is an instruction to be given relative to written notice.
Well, again, I think some of the confusion is that some of these protected activities overlap. And so, like in Edwards, they say that a whistleblower could be acting under one of the three bases and really have an argument under another. I understand
They're going to be treated. It's my job to take that pot of spaghetti and see whether or not the separate strands withstand evidential muster.
Right.
So,
insofar as he's the decision maker, that would lend toward it being internal.
Okay.
But
so
typically, an elected official would, under the case law.
You can't have this both ways.
Right. So then, with respect to his whistleblower, he's the decision maker, so he's still in the chain of command.
Okay, so he's not an outside body. Is that what you're saying?
Yes, Your Honor.
Okay. All right, so that straightens one thing out here, but not much more. Now let's take a look. I think everyone would agree here that the chief is a supervisor. I'm not going to put that he is a supervisor, but there's no quarrel, so to speak, amongst lawyers here. Okay. And I'm not going to belabor what a retaliatory action is. Okay, now let's get into the tough stuff here. Under B1, that Lieutenant Dodge disclosed to a supervisor. I don't think he threatened to do anything, so I think it's disclosed to a supervisor, okay, an activity or policy or practice of the employer that the employee reasonably believes in violation of law. So you're moving forward on that, I take it?
Yes, Your Honor.
Okay. And just for the record, what is the evidence that you're utilizing to support that?
His objection to the manner by which the town and its police department were administering.
If you could speak up a little bit more.
His objections with respect to the manner by which the town and its police department were administering civil service laws and requirements.
Okay.
And in discriminating against an African American coworker.
Okay, so let's talk about those objections, because there's that dovetails, so to speak, with number 3, which relates to objecting or refusing to participate in certain activities. There's evidence that he never told anyone that Chief Haig was acting based upon racial animus. Okay, I think that's been fair, other than perhaps Patrick Buchanan. Okay, but he never complained at a supervisory level. That's fair to say, right?
That's right. He didn't say that to the supervisor. That's correct.
How is the grievance, which is, pardon me,
It's tab 11, Your Honor.
so what is the violation of law or rule or regulation that forms the basis for your claim under B1 based upon these 2 letters?
He cites the civil service laws, Mass General Law, Chapter 31, Section 41, and states that the department's not in compliance.
Okay. You're looking at tab 11.
Yes, Your Honor.
Where's reference to?
Oh, I was looking at the second letter, Your Honor.
Okay, I'm looking at the one to Chief Haig.
Okay. So, civil service appeal is the subject of the letter.
I understand this is an appeal.
Right.
Okay. Is there anything more, let me put it this way, than the implied notion that there's a violation of law because this is an appeal that is set forth in this letter that I should be mindful of?
Yes, I asked Lieutenant Dodge if disparate impact was argued in these proceedings, and he said yes. And so, the disparate impact or the disparate imposition of punishments under civil service or treatment under civil service is what he brought to their attention at these hearings.
What do you recall in that regard? Because I've got 90 pages of notes, and I don't think I recall that. What disparate, mindful you're talking about testimony, and Lieutenant Dodge was not terribly detailed in his recollection of what, if anything, he testified as to. So I'll be honest, I don't recall any sort of comparator evidence being adduced at those hearings.
I agree that we didn't, Your Honor, I did ask him the question. Was unequal treatment or disparate treatment part of your grievance and what you argued? And he said yes.
Are there, other than the grievance as being a violation of B1, are there other bases for a violation of B1 that you are setting forth?
I get just flipping my mind. So B1 is the
A threat, disclosing to a supervisor a policy or practice that the employee reasonably believes to be in violation of a law.
right. No, that would be his communications to the chief, mayor, arbitrator, and through the process.
Okay.
Yeah.
Okay. So. Okay. Anything else before I turn to Attorney Keston, and then we'll turn to B2.
He did provide a statement when he found out that Buchanan was under investigation, in which he says he believes Buchanan had no malintent.
Okay, that was the letter to Lieutenant Burge?
I believe so, Your Honor, yes.
Okay.
I think that's tab 7.
Okay, so the inquiry here is in whether or not I instruct on B1 or not as a matter of law. So, Attorney Keston, your comments, please.
The evidence is crystal clear in this case that Lieutenant Dodd never complained to anyone out loud about racism, about race-related things. He didn't say it. He didn't say it to the chief. Filing a union grievance, he didn't mention it in the grievance in the slightest. There's nothing in any of the paperwork that he filed with anybody in which he suggested that there was a discriminatory motive or that something was illegal. It's a routine grievance. There's nothing here. So the concept that, even if he did argue that other people got less, he didn't say it was because of something illegal. This is all routine stuff. And Tamburello says, which we cite, Your Honor, says that this kind of activity, if you retaliate for doing grievances, for union activity, he was acting as a union president.
Okay, what page is that on in your...
Oh, it's in our motion for directed verdict.
It's our motion for directed verdict.
And it's on.
Can you just give me the citation? I recall seeing the word Tamarella, but I haven't looked at that yet.
The one that knows.
This is where you said that they should have sued under the NLRB.
Yeah, that they have jurisdiction. If a union member,
I understand.
actually defended most of cases. If it's union activity, then it has to go there.
I understand.
It's sort of like 151B, that if it's discrimination, it has to go there. And so here they're claiming that the chief discriminated against him because of his union activity, unquestionably.
Okay, what is the...
What's the site? 67 F3rd 973.
Okay, very well.
First Circuit 1995.
Okay, I'm going to move us forward. E2. So this is the testifying before any public body. Okay? Why don't you tell me what your recollection is of his testimony? I can go back and check, but it was not detailed.
You want it? We have the tapes, so we can give everybody the exact testimony if they want, but we are going to listen to it.
Yeah, I mean, you could...
I have the tapes of the trial.
Right. Well, it's not to break it to you, but we don't do tapes anymore. It's all online. So
Your Honor, it's exactly right.
And you all have access
I have the vinyl recordings of the trial.
Yeah, you all have access to FDR, obviously, so let me hear from you first, and I will go back to my notes and check this. But I think some of the answers were, did you testify, for example, at the grievance hearing before the mayor? I don't remember. Did you testify before the arbitrator? I don't precisely recall. There may have been something mixed there. I can go back and look, but please tell me what your recollection is first.
I recall getting some yes answers to disparate treatment and unfair treatment of this officer. And then the follow-up question is...
when in his testimony? So this is Lieutenant Dodge's testimony?
Yes, Your Honor.
Okay, bear with me a brief moment. Did he use the word disparate?
I did, and he affirms that.
Hold on. Okay, that word only comes up in a motion to eliminate. Okay, so it's not there. Let's see. How about this? Testify. One moment, please. Okay, Patrick Buchanan testified. So this is at approximately, let's see, he started testifying at 9:28 on April 12th, so this might have been around 10 o'clock or so. There was a hearing before Mayor Martin. In the hearing, it says that he and Todd Dodge were present. There was an attorney on behalf of the union. The hearing was not long. In the hearing, the mayor didn't identify any negative aspects, rescinding. Then he goes on to talk about the arbitration hearing. At that hearing, the plaintiff and Todd Dodge testified. Doesn't recall who testified on behalf of the city. One moment, please. Okay. And then here, Attorney McDonough's examination of Mr. Buchanan. Todd Dodge was before hearing it to the mayor. Oh, here it is. I'm not losing it. Resumption of cross-examination of Todd Dodge at 11:32 on April 25. He had just reviewed the mayor's decision at tab 12. He doesn't recall what he said at the hearing. Pat Buchanan said he asked the young man to provide him receipts. Oh, okay. I'm really not crazy. He doesn't recall what he said at that hearing. Further, he doesn't recall if he testified at the arbitration hearing, which is so I've got Patrick Buchanan saying that Todd Dodge testified at the arbitration hearing. But I've got Todd Dodge saying that he doesn't recall what he said at either one of the hearings. So apart from whether or not he actually testified, there needs to be some substance, which gets back to my initial point that even if he did testify, what's the evidence as to what he said? Because under B2, he has to provide information to, so I don't know if you provided information or testify before, okay. Provides information to or testifies before any public body conducting investigation, hearing, or inquiry into any violation of law. So, if the facts demonstrate, unless you can point me to something, and I'm happy to hear from you, and maybe I should turn to Attorney Keston while you're looking at that. If you can point to something as to what he testified as to, I'm not convinced that the simple fact that he testified is enough for this question to go to the jury. While you're looking at that, let me turn to Attorney Keston on this point. What do you have relative to the issue of Lieutenant Dodge testifying before the mayor or the arbitration?
Well, I'm working strictly on memory. As I say, tomorrow I'll be working exact to, I have no memory to testify further, even if he did. If he had said, what you did is illegal, what you did is discriminatory, at a hearing and they retaliated against him, I think it's still in RB territory, but maybe. It's clear he didn't do that. And I don't believe he said anything about it. I'm pretty confident that he said he didn't remember if or what he said. But if you even assume for the moment that he said, yeah, I did testify that other people got less discipline, that's not disclosing something illegal. That is standard stuff.
I don't even need to go there because I don't have any evidence as to what he said.
As I say, we will have it.
Are there any exhibits that have not been referenced that are somewhere in the tabs that evince the testimony at those hearings?
No, Your Honor. But I do believe it's in his testimony. I wasn't taking notes when I was asking him questions. I just have my questions. And
I understand that you were otherwise occupied, but this is where the rubber meets the road, and
Well, I'd like to review I know I asked him this question, Your Honor. It's in my outline of my questions, he said yes. This was part of our defense, disparate treatment, and I think that I can find that for you on the audio.
Yeah, saying this was part of our defense, and I do recall him saying at some point, not part of their defense, but part of the claim was disparate treatment. That doesn't mean that he testified as to that. I'm only looking at B1.
Right.
B2, pardon me. All I'm looking at, and right now I'm disinclined to allow any charge on B2 because my recollection is that he just doesn't remember. And I'm not certain of the foundation with which I can go forward. And if you can point me to a case that says all he has to do is say, yeah, I testified, and with nothing more, I'll consider that.
Well, it's under B2. It provides information, so I think eliciting testimony or helping the underlying person give that information, or even his letter to Lieutenant Burge would be part of that same investigation. But
okay, so that's fair enough. So let's talk about that. Providing information. This is where it's the double-edged sword, because it has to be an outside public body.
I'm just reading from,
and I'm not going to hold you to your earlier representation necessarily relative to whether or not the mayor's office is a public body, but under Christo, it's got to be an outside public body.
just as public body. I'm just reading from page 230, and it says any public body.
230 of what?
Christo.
Hold on a second. It's in here someplace.
Public body as using the act refers to an outside public body, not the employer.
Head note 4.
Yeah, I'm just looking for the part where it says outside public body. All right, so I will look for that, but getting back to your point, provides information to any public body.
And it also says assist in a public body's investigation. So it's just a lot broader than testify, even just mere assistance, Your Honor.
Where do you, I'm looking at the statute.
I'm just reading from Christo, which cites to the statute, but again, that's page 230 of Christo, head note 5.
One moment. right. Attorney Keston, what do you have to say in this regard, please?
My head's exploding. He has to complain of wrongdoing. He has to blow the whistle on something. I mean, now he's arguing that that everybody that talked to them about the investigation somehow is protection. They're whistleblowers because they said something. The fact that he was lots of people were part of the investigation. Lieutenant Dodge had to stand up and complain to somebody that something was going on that was illegal. He didn't.
Okay, let's talk about that, because that's a separate issue that I wanted to. That segues to paragraph 3. One moment, please. So, and this is truly where 3 and 1 are interrelated, okay? There's no doubt. One is almost the inverse of the other. So, number 3, objects to or refuses to participate in an activity. Oh, pardon me. That is not what Attorney Keston's point was, but Attorney Keston's point is that a grievance is not an objection to an illegal activity. We actually already covered this. Your point was that implicit in the appeal was the notion that this was illegal activity, and there was reference to Chapter 31 in the letter to the mayor, which is at the back of tab 11, I think it was.
Yes, Your Honor.
And that was it. Okay. Now let's take a look at number 3. So here, this is that he refuses to participate in an activity, and your argument is that, pardon me, he refused to do the workaround. Okay, so what is the evidence that he refused to do a workaround?
The chief asked him if they could find a workaround or loophole to Buchanan. The discussion was about Buchanan being number 1 on the list. There's evidence that number 1 on the list is required to be promoted provisional sergeant.
Right. So, but what is the evidence that he refused to do a workaround?
He testified that he did nothing in furtherance of that request.
That much I got, that he did nothing. Okay, but how is that?
And I think he said something to the effect of, "There's nothing that can be done," to the chief. So that's an objection or refusal, Chief. There's nothing that I can do. I'm not going to do it. And that's the inference the jury can draw.
All right, Attorney Keston, in that regard, please.
I'll get the audio. No, he didn't. I did insult him, Your Honor. I mean, he said he didn't want to wake the bear. That's what he was never going to say to me. He didn't say I'm not doing it. You know, it's just not the evidence. In order to get whistleblower protection, you have to go to your boss and say, what you're doing is illegal, I'm not doing it. Now you're protected. But because you're thinking in your mind, he didn't say that. I believe he said, I don't want to say what I believe, Your Honor, because we'll know.
Let me take a look here, because I think he said both things, actually. He most assuredly said, and he said a lot, that he didn't want to poke the bear. But let me take a look and see.
What day are you looking at, Your Honor?
I haven't gotten there yet.
Okay.
Bear with me.
Oh. Yeah.
Okay, bear with me now. Okay, so here I'm at 1148, direct examination of Lieutenant Dodge.
What date, Your Honor?
I'm getting there, just a moment.
Sorry.
Of April 21. Let me take a look here. Chief said we need to find a workaround.
What time, Your Honor? I can play it if you give me the date.
Actually, this would be about between 12:14 and 12:18. Funny you should ask. I'm not going to have you play it right now.
What
Okay.
date?
The 21st.
Okay.
So this would be sometime around 12:16, 12:17.
Yep.
Chief said we need to find a workaround on the list. Chief wanted to find a loophole and wanted have him find an alternative to the list. There was no cooperation and there was no alternative for him to explore. He wouldn't find a loophole around civil service and feels the civil service law has to be followed. Race is not a proper reason to go around the short list, and he would understand that is a violation of the civil service laws. At that time, the chief said nothing about Ting, so here this was just a shift to a different issue. All right, so bear with me a moment, please. Okay, I think I could at least establish that he had a feeling that this was the wrong thing to do. What I'm trying to get at is that he actually refused to do something. But that would be just a hop, skip, and a jump from what I just read. One moment. Okay. And my sense is that I guess what I was looking for is there any testimony that he went to the chief and said, I'm not going to do that? That I don't recall. I certainly believe it is established that he felt it was wrong. And I think everyone here would agree upon that. But is there any testimony that he actually acted upon his feeling?
I think he told the chief that he could not do that. And then the statute says objects to, or refuses. So
Okay.
to say under oath, I did not cooperate with the chief's request, satisfies refuses.
Okay. All right. Anything further on this point?
Not until we listen to it.
Okay. Okay. With that wonderful backdrop in mind, yes?
Is it too soon to inquire about whether I should call the jurors?
Oh, thank you for. We still haven't done the jury verdict slip, which I looked at yours, and that's just not going to fly. And I haven't had a chance to look at yours. My sense, to be honest, is that we have a fair amount more to do. We have to wrap up here at 4:30 because the building empties. Then tomorrow we have a late start. I don't think that I'm going to have my final jury charge to you all until probably somewhere, if I scramble, around 12:30 or 1, because we still have to talk and then I need to make revisions. When I draft up a jury charge, I just put everything in there and then just take things out. Okay? There might be things that I need to add, but it takes time. And then you need to review it so you could shape your closing, and we also need to I just don't see it happening for tomorrow. And I do apologize for my personal schedule, but let me just say this. I never thought this case was going to go on this long. Never. And it kind of is what it is. So I think that it would be appropriate to give everyone a little breathing room to tell the jurors that we'll see them next on Monday morning.
No objection, Your
I agree, Your Honor.
Okay, so, Mr. Buchanan,
For all of us, especially you, to have adequate time to do the work you're going to have to do.
I have nothing to do tomorrow morning.
I do.
Yeah.
We know.
No, I'll be quite busy. Okay. All right, thank you all. Let's
I'll make
press.
those calls, Judge. Thank you.
Great. All right, thank you. Ask them how they're feeling.
I will.
Yeah. Let's press forward. That answers some of my questions that I raised during my research. Let me go back now to Attorney McDonough's. Okay. You have something in here that there's no requirement that the city of Greenfield needed to be aware of the protected activity at the time. On page 7 of your draft, Attorney McDonough. At the time the activity occurred, so long as the employer knew of the protected activity before taking you can argue that, okay, but I'm not going to include that in a charge. You both had similar language on retaliation and temporal proximity. And then here, on my draft, I'm not going to repeat all that I've stated relative to the nature of direct and circumstantial evidence when it comes to actions on discrimination or comparators or unexamined bias and that sort of thing. I'm not going to repeat it for each of these plaintiffs because I'm repeating the same thing. Okay. And you can argue that, you'll see in my charge that you'll hear something about, bias that pertains to my clients, if that's your argument. Okay. All right. Circumstantial evidence. We've discussed general atmosphere of discrimination. That's not happening. Okay. Mixed motive. Those sort of things. Those mixed motive that goes squarely to Mr. Buchanan's claims. Damages. The treble damages are statutory, and although it's not specified, it's my understanding that those, and I think that you may have referred to them as punitive damages, but statutory treble damages, that goes to me, not the jury. So I see the damages relative to your claim for Lieutenant Dodge as being emotional distress, which, by the way, the SJC really gives short shrift, or the model instruction really gives short shrift on emotional distress damages. But it seems to me that it's fair game that he's got a claim for emotional distress damages and back pay. Okay? There was all this testimony that he was on administrative leave, and I presume he got his straight time pay. He just didn't get his overtime and detail pay. Am I correct?
Yes, Your Honor.
Okay, because that wasn't quite fleshed out. But so in terms of damages, I see it as back pay and emotional distress.
Just for the record, the treble damages and attorney's fees are things that we're going to reserve if there's a plaintiff's.
Obviously.
Right.
Obviously. You're not done with me yet. That is, if you win. So.
I think you're done with it.
No.
Okay, so this whole portion of punitive damages, that just obviously that
Understood. Yeah.
Is there anything? Now let me take a look at Attorney Keston, your draft relative to Lieutenant Dodge.
They're over there. I don't know where they are.
Okay, so here too, I'm at page 17. You've got this burden shifting on request number 15. It's just the second paragraph. The first paragraph is fine. But if the plaintiff meets this burden, then the city of Greenfield must articulate a legitimate non-retaliatory reason. That's
I think we're talking about Dodge,
I am talking about Dodge.
but there's no discrimination cases.
I'm reading yours.
He's reading retaliation.
Page 17. Retaliation and violation of Whistleblower Protection Act generally. It was in an overabundance of caution. I'm sure that Attorney Brody included it, so that's fine. All right, protected conduct. This mirrors what we've discussed. Reasonable belief. There's language to that effect. That was at page 19. Page 20, adverse employment action. We had that. Unfairness is not necessarily retaliation. I've got something that's similar. That's the shabbily or unfairly language. I didn't incorporate that much. Let's talk about causation. Substantial motivating role. I think the model is a but for. And in general, obviously, we no longer, we've eliminated substantial contributing factor in the context of tort cases, but at page 22 under causal connection, you have that a retaliatory motive played a substantial motivating role. And let me take a look, but I believe that the model is but for. So one moment, please.
Is it here? Did we talk about this? I don't think so.
I'm listening.
I believe it's the determinative cause standard. Edwards clarified that that's the
It is. It is determinative cause, but also it's a but for language. Hold on a second. Oh, here it is. If it is sufficient if retaliation was only one motive for the retaliatory act, so long as those actions would not have taken place except for, the motivation to retaliate. So it's a but for, so that's the model language, okay, thank you. Other than that, that was fine. Okay, let's talk about your request number 21. Your second request was the business judgment, which I've allowed separately. But I'm not yet convinced as to paragraphs 1 and 3. Protected conduct does not cloth the plaintiff with immunity for past and present inadequacies, etc. Is there an objection to that?
Yes, Your Honor.
Okay. And then the next one, by engaging in protected conduct, an employee does not acquire immunity. This is very similar from the same risks. Okay. The anti-retaliation law is neither a shield nor a statutory guarantee. Okay, so why don't I hear from you relative to those two paragraphs, please?
Which you?
What's that?
Which you?
Which you?
No, which you want to hear? You said you.
That's the royal you. So whoever whoever wishes to speak.
From Blackie. From the Blackie case. I don't know. Your Honor, this is just language from the Blackie case, Blackie versus State of Maine.
Okay, so I take it that was not Massachusetts law.
It's First Circuit law.
First Circuit.
Oh, that I were a federal district court judge. in Maine.
Understand you're not bound by it.
No. Okay. All right. I respect that. Okay. All right. Why don't we move forward? I'll take a look at that. Okay. Then, pardon me. Page 24, paragraph 1, we have this burden shifting again. Looking for a legitimate non-retaliatory reason that comes out. I'm considering adding the juries do not sit as super personnel departments. Is there any whole cloth objection to that one? That's one that we oftentimes see.
That's kind of a generic one for the whole case, correct, Your Honor?
Correct.
Yeah.
Okay, very good. No objection. Thank you very much. Business judgment, I've discussed 18 times. I always have something, the fact that I'm instructing you on damages is no indication that you're going to get to that question, so that's all right. And the rest of the on damages, back pay, emotional distress, and obviously those are all fine. Okay. Anything else? Yes, Attorney Keston.
Question, Your Honor, from Buchanan, Buchanan's jury instructions. Did we discuss unexamined bias?
Let's take a look at that.
Page 4, depends how you print it.
All right, one moment, please. Hold on. You know, this is the implicit bias instruction is in here that we're required to give.
But that's to the jurors.
That's
The implicit bias instruction is directed
right. Yes,
to the jurors and the way
right.
they deliberate.
Right, fair enough.
Not to the.
I understand what you're saying.
Police.
One moment, please. One moment.
You're like, where is, I don't know. Don't ask me, because look, 1, 13, 4, 13, 19. No. Well, yeah,
I apologize. One moment. Just while I'm going through this, and I'll get to this point when we promote. When I say the mass anti-discrimination statute makes it unlawful for an employer to refuse to hire, promote, or discharge some blah, 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 so I'm based on, I'm not listing all the categories. I'm just going to say race. Okay? So bear with me a moment. C3. Okay, here it is. This isn't a model, okay? But fair enough. I'll hear from you, Attorney Keston.
As I understand what the SJC has ruled, what the model says, that's instructing the jury into how they
Right.
make a determination, not saying that the defendants can be liable, which is what they suggest, because they unintentionally discriminate.
Yeah, but this is in the MCLE charge. This particular unexamined bias is in the model jury instruction for the Superior Court.
So, I haven't seen any cases of this. Are we saying that if
It's the plaintiffs have cited the cases.
well, we'll look.
Bulwer, which is
Verdrager versus Mintz-Levin.
Verdrager versus Mintz-Levin. Look at page 4. I'll take a look at these cases.
We disagree that those cases stand.
I'll take a look at those cases. All right. Okay, thank you. I understand the nature of your objection. Let's talk about the jury questions. Now here, from where I sit, I had a full head of hair before I had to deal with my first complex special jury verdict form, okay? When counsel can't put their heads together, because this is what leaves judges scrambling in their lobby. And what happens is since we do all our own typing, end up with formatting problems, okay? And it gums the works up for me not to have this ready, set to go before we sit down with the jury, because then I'm sending jurors off and they don't have the special jury verdict slip form. And I like them to have that from the start. So let's take a look at this. I'll ask you please to get them in front of you. I have an amended verdict slip. One moment, please. I think this is the same thing. Okay. Okay. Just to make my short shrift of the plaintiff's proposed, so we could dive into where we're going. Certainly, there'll be no imposition of treble damages by the jury. And in other regards, I see where you're heading. I have concerns about this. Okay. It doesn't. First, I don't believe that it adequately identifies the entry points, so to speak, or jumping up points for damages, to the extent that there were two demotions. Okay, and arguably a jury might feel that there was discrimination. I'm only speaking Mr. Buchanan, obviously, relative to one of those points. Okay, now if it's and then he was promoted. So actually, whether it's the first or the second, it seems to me that we need to break out whether or not they maintain there was discrimination in point number one and point number two, because they may say that there was discrimination arguably or hypothetically in point one, but not point two. That may happen, okay? So that's why I suggested that I don't think that this works, okay? And it's certainly, for better or for worse, it assists us in acting with some appellate efficiency, so to speak, to ensure that these special jury verdict slips addresses different issues, so that we can, or you all can identify what appellate issues or what issues need to be fleshed out on appeal by pointing to specific answers to questions. So having said that, let me take a look at defendants, which I apologize, I have not yet even seen. Okay. Question one. Let's go through this together. I did eyeball it. I thought it was, based upon the first page, I thought it was on the right track. Proved by a preponderance of the evidence that the internal affairs investigation conducted on January 15th was initiated because of racial bias. Apart from the language, the wordsmithing here, let's move forward. Did he prove by a preponderance of the evidence that the chief's discipline was motivated by racial bias? Okay. Did he prove by a preponderance of the evidence that but for, okay, his discipline and demotion, he would have been promoted following the January 15th assessment center? Okay, catch your heft. It's the causation. Did he prove that, now we're into 2018, so I presume that these are similar. I'm not paying attention to If you answered yes, then you go on to the others, because this is the other thing that drives us nuts, because we oftentimes find errors and we have to. Okay. Interesting. Also, question 6. So the 6 is taking me down from the first cause of action. Is that correct?
And second. Yeah.
Damages for the first. And hold on a second here. Okay, so you have them lumped together as well. Okay, so at least here I have a delineation of causes of action relating to 2015 and 2018, which is on the right track, okay? The one thing I would have expected to have seen here is, and this gets really confusing, if you break it out into two sets of damages, they'll overlap, or they may overlap. If you all want to leave it as one lump sum of damages, I suppose the way that you've set this forth, we will know what they relate to, because they'll say, did you find there was discrimination in 2014? No. Did you find there was in 2018? Yes. Do you find damages? Yes. Ergo, they flew from 2018. So I have less of a problem with that. Let's stick with that for a brief moment. All right, Attorney Ryan.
Yes, Your Honor.
Your thoughts relative to this working draft?
Your Honor, I mean, what they're doing is they're ignoring half of the case. They don't have anything in here about the September or the fall 2014 shortlist and the failure to promote off that, when in fact, obviously it happened to Westling just months before, nor is there anything in here, Your Honor, with respect to the 2021 promotion process, which obviously they bypassed him. He was number 5, and they chose number 6 for the last spot. Breaking it out this way is really the defendant's best case, because it doesn't allow us to put into the jury the 2014, 2015 promotional process. If we do it that way, the 2014, 2015 process, and then maybe we have to put in the 2021 promotional process, Your Honor, as well.
Let me focus on that for a brief moment. Your response in that regard?
My response to that, he has refused to cooperate with us. We started in the beginning of this trial with, we need a verdict, and Mr. Ryan wouldn't do it. Then they submit a general. They haven't done it. I'm happy to work with them.
Okay.
I am happy to work with them to add whatever they want.
I'm going to ask you all to do this. It's 4:09. Take 20 minutes. Stay where you are, and see what you can do. There is no doubt that what you come up together is going to be better than what I come up with, okay? Which is why we asked you to do this. Just put any differences aside and focus on this as your issue, okay? And I'll step out here at 4:25, so we'll give you 15 minutes. My point simply being that there are various causes of action for discrimination that's at play. And I got to take a look at Lieutenant Dodge before I send you anyway, but it appears to me that that's pretty simple. There are various causes of action. They have to be identified, okay? Otherwise, we won't know necessarily where the jury found discrimination or not. That bodes well for everybody here, okay? Well, that benefits you rather. Okay, then let me take a quick look at Dodge. Did he prove by a preponderance of the evidence that now, I didn't get one from you, did I?
Well, I joined and collaborated with Attorney Ryan on Friday's submission.
Okay, so yours is pretty threadbare here. Dodge. Did he prove by a preponderance that the internal affairs investigation conducted in 2015 was initiated because of whistleblowing activity? Okay. What amount of damages would you award to Dodge for really engaging with that you found the defendants to have committed against him. I'm not convinced that that really clearly sets forth the claim on the defendant's part. I'm going to ask you both to take a look at this now. I'll come back out. And you're free to go across the street and continue to deal with this, but please take a look at it. Let me talk for a brief moment about our schedule. We will start at I have a sentencing at 9 that should go until 10, at which point I'll be heading right back up here. So as soon as you're done, Attorney Keston, I shall be here.
Where are you coming from, Your Honor?
Springfield.
Springfield.
We're
having a practice tonight, so I will talk to the team, the MC League folks, to see. But I'm confident, I'm relatively confident I can certainly be here between 11 and 11:30.
That's fine. If you have portions of the recording that you would like me to listen to, I'm happy to do so at that point in time. And at 3:20 is a hard stop for me. I chair a trial court committee, and I've got lots of people waiting for me at 3:30 on Zoom, and so I apologize, but I have to do that. That's a meeting that doesn't occur too often. So, but I think that we have sufficient time to work through this. I appreciate your time. I appreciate your considerations and listening to me earlier. And once again, I apologize if I put anyone off. I'm simply trying to do things efficiently, and I let my emotions get in the way. I apologize.
Me as well.
All right, thank you. Okay, take your time. I'll be out in.
He's zipping in.
Okay, very well. Yeah, I don't anticipate that you would have finished this, but I want you to start it. And you need more time, I take it, right?
Sure.
Good. Well, fortunately, you work well beyond 4:30. But I'll ask you to continue your discussions if you are possible this evening, but certainly tomorrow. And the good news is that we do have until Monday. But please, these are the sort of things that are truly best handled by you all. I know that you can find common ground here and at least get yourself closer. Okay? I do appreciate your having taken the time. I wish you all a good night. Have fun with your webinar, and I'll look forward to seeing you. I will be back here around 11 or so, and we'll get started as soon as we can. Okay?
Thank you.